to the mic. You keep on rambling while I continue handling mine. Underground rap editorialist.
What would you say you do here?
Here we are. Whoop-de-friggin-do. DYOJO Podcast made it a year, so welcome to the show, I guess. I gotta be honest. I've not been nervous for a show in quite some time, and my wife said I snored last night, and I'm pretty excited. We're splurging. I've got so much. Any of you that run podcasts know I've got so much DYOJO podcast money. These books are flying off the shelves. And so as a gift to myself, I went ahead and splurged, and I got myself a copy of First Degree Burned by Robert H. Packrell. This puppy was published in 1989. Cliff Zlotnick, IAQ Radio, helped me track down Robert. And I had to get a friggin' money order, send it to Bob, and pay for my own shipping. So that's where, when you support the DYOJO Podcast, this is the kind of stuff we're spending our money on. So super excited. This, I got to talk to Bob. Hopefully we can get him on the show. This is like a devotional or a meditational guide for restorers. There's lots of great insights in there. Cliff talks about when Bob used to teach classes, and our mystery guest was going to help me try to track one down in his treasure trove. So pretty fun. There's just a lot of artifacts and relics from the industry going around. And so that was a fun find that took a while. It took a while to get a hold of that. So just to give you a little bit of a timeline on this, we've been assaulting your eyes and ears for a year now, the DYOJO Podcast. And so what's the history of that? Doesn't really matter, but just to give shout outs to a few people that have contributed. In 2016, I think I wrote my first article with Restoration and Remediation Magazine. Michelle Blevins published that in the on the website. And then we fast forward to 2019. She helped come up with the name, The Intentional Restorer, as we were. I wish I could remember. Probably have it written down somewhere. Some of the other names we were considering that were terrible. So shout out to Michelle, and credit to her for allowing us to assault those your reading ears and mind, however that works, whatever you use when you read. But I've enjoyed writing for a long time. Michelle encouraged me, hey, if you publish some videos, maybe people would read your articles. And then my friend Greg Power, he was saying the same thing. You got to do some videos. Unqualified Success by Rachel Stewart. That book and a conversation with her really encouraged me to release our books and solidify the DYOJO brand. Our good friend Jarrett Steer at GMS Podcast, he shared how he was doing his podcasting, let us peer behind the curtain. And then I was on Andy McCabe's The Claims Clinic. I think we were the launch and the close of season 2. So, but Andy was like, get a good camera, get a decent microphone. I'm a cheapskate, so I got, the low end of, and we've made it work. So, and that's pretty much what our podcast is, the low end of it works. And then where all of this, our first, I suppose, official guest, when we called it 3 Questions with a Pro, was our good friend David Princeton, who's become our good friend. But where we all intersect, and this is the, let's see if I can do this, where we all intersect. That's a picture of our mystery guest. Mark Springer got it correct. Michelle Blevins got it correct. I haven't checked recently to see who else got it, but we actually, Ed was the first, Ed Cross, the restoration lawyer, restoration advocate, was the first guest of the DYOJO podcast. And we did, it was an article / interview for a history of collaboration, a future of advocacy. So as we were putting together Ed's timeline in the industry, and then the development of the standards of care, the standards in the industry, this name kept popping up. This guy, Pete Consigli, Pete Consigli, the restoration industry consigliere. And so I reached out. He had a Yahoo account. So Pete still has a Yahoo account. And he was pretty resistant. Let's say that. It was like, we opened the show with, what would you say you do here? And that was almost verbatim what Pete said when I first reached out. So it's been about 9 months, a year of going back and forth. But Michelle and Pete wrote a really great article. Pete is a library that everybody that knows him refers to him as Restoration Google. And actually Ed's going to introduce, Pete's going to introduce Ed here shortly. So I'll stop rambling, but funny story. I want to tell people about Ed. A lot of the clips, the cool swirl in with the intentional restorer, Ed Cross, our interview, for whatever reason, didn't record on my end. Ed is gracious, talented, gives hours and hours behind the scenes. But he saved the video that otherwise would have been lost to the ether, whatever. And he also created an intro video. And so for all season 1, you can see that intro video that Ed created with the music. So we've chopped that up, and my friend Danny Morgan did some music for the intro. And I was pleasantly surprised. That's Ed drumming as the beat kicks in on the new intro. So anyways, I'm gonna show a short clip, and then we will keep moving forward. We want to talk about Be Intentional culture.
In the Be Intentional culture book hug moment.
We got the hugger in the house. That's awesome. We got the hugger in the house.
Here's your hug book.
Oh, there we go. Getting all techie. You gotta do this. Getting all techie. Gotta hug the book.
We got the hugger in the house.
Book hug moment. There you go.
We got the hugger in the house.
So it is what it is. Intentional culture. Getting all techie.
No.
We got the hugger in the house.
So it is what it is.
No. Well, there you go. There's our attempt. So speaking of hugging books, let's click over to our waiting room shortly here. And hey Ed, how's it going? Oh, looking ripped. How you
doing, buddy?
Good. We will cue over to you shortly. Thank you for being patient with us.
I'm here.
Okay, so drum roll, please. We are our mystery guest, as we've already said, is Pete Consigli, the restoration industry watchdog. Decorated. Let's see, what do we got? The 2008 RA's most prestigious honor for excellence in restoration, the Martin L. King Award. 2012, RA made Pete the second honorary member to its association, only the third such honor in RIA 70 plus years. Short plug, which we're celebrating this summer in Florida. You're not going to want to miss that, the Diamond event. 2015, Dallas, Texas, the Indoor Air Quality Association inducted Pete into the IAQ Hall of Fame. And so he's been active. That's just a short list. If you don't know the name Marty King, Marty L. King, you need to. Unfortunately, Marty is no longer with us, but Pete is about as close as you can get to this founding father, which is an article that Pete wrote and we referenced. A great place to start if you want to know more about Marty and about Pete is an article Pete wrote in August of 2015 in C&R Magazine, The Man, the Legacy, about Marty. And as I said, I've been working for over a year to try to get Pete, the gatekeeper, restoration history, Google. Somehow I broke in. I want to tell you, if you're looking for restoration history, and if the person you're reaching out to doesn't say, have you talked to Pete about this? You're probably talking to the wrong person. And Pete, probably, one of the best compliments, it was also what Lex Cisney said. He was a guest on episode 22 is Pete said, you're a persistent bastard. So I take that as a compliment. He's a regular guest on IAQ Radio. And again, if you don't know what the frig IAQ Radio is, you need to, every Friday, 12 p.m. Eastern time. These are the OGs of restoration podcasts. They were doing podcasts before podcast was even a thing. So I'm going to introduce Pete, and this is a special. I want to share this photo with you. I am so tech savvy. That's a picture of Pete and Ed hanging out in Las Vegas at an industry event. So this is in the 5 questions in 2020. Ed was asked about who would you name as your most important mentors and why? And Ed said, that's easy. I need to mention only one, G. Pete Consigli, CR. He taught my very first water damage class back in the mid-90s when I knew nearly nothing about the industry. I walked up to him after that class and introduced myself, and he changed my life forever. He took me under his wing and helped me build an extremely rewarding career. Not only did he teach me how buildings are restored, he taught me how the industry works. He got me countless speaking engagements. He introduced me to my first bunch of clients. He made sure I was in the right place at the right time. And he did it all with no expectation of gain. He's more than a mentor. He's a family. And I am forever in his debt. I love you, brother Pete, and your big Sicilian heart. So without further ado, Pete Consigli, the industry watchdog. Pete.
John, reading that thing from Ed, you kind of choked me up. While you were doing some of the intro, since I have a lot of things in my hands, I'm going to start off with this.
Yes. Thank you.
And a special little note that you put in there. That's what I was referring to the other day when we talked. I really appreciate that note. But I'm also very interested. I don't want to say more interested because they're two different things, but so.
Oh, dang!
Because
we got a double header.
I'm at the heart of it, I'm a project management guy. So understanding, estimating, scoping, all that, is one of the critical factors of any service-based business, certainly in restoration. So thank you for those books.
Yeah.
Now, I'm so happy that you got the 3rd degree burn, because I had one of those books. I looked at my storage and I couldn't find it. It's probably there. I'm glad that they're still available. Exactly. And the one story in there for your audience, so they know, Bob Paccarella is a true original pioneer from Tennessee, the spotless janitorial, and he went into cleaning and restoration as his company. And he's a very interesting guy. But the one thing, it's a story, it's short vignettes of the early days of restoration, the dealings that restorers had with customers, insurance companies, et cetera, et cetera. And the one in there that was one of our favorites is he calls the Wheel of Fortune. And he said that he had the check from the insurance company, and he had the homeowner's name was on it, and he had to swing by at the end of the day one time to get it signed off from Mrs. Jones, the proverbial customer. And anyway, she said, Mr. Becquerel, you people did a wonderful job, but there's a little bit of a smoke odor, and I'm hesitant to sign the check and I get it out. And what happened is, he said, well, where is it? He said, well, it's in the kitchen. So he said, well, just wait here and let me go in and check it out. And so what happens is he goes into the kitchen and looks around. There's a ceiling fan in there. So he takes a $50 bill and he tapes it to the bottom of the fan. And then he comes back and he says, come with me here, Miss Jones. Let's take a look. I think I might have resolved the odor. So she looks around like this. He goes, and I paraphrase the story. It's in the book, but this is what I remember it. And he goes, I do think that you've rectified this odor. And anyway, she signed the check and gave it to him. I don't know that you can make a story up like that, but if you can, but it's a funny story no matter what, even whether if it's not true. And back in those days, the deductibles were small. A lot of times people may have had the money, they could pay the deductible. They didn't want to necessarily tell you that. And these are the kinds of things. Ed's probably really nervous in the room now. Oh my God, Pete's going out on the edge. Make sure he doesn't step over the line on the antitrust rules and all that. I know how to get to the edge without going over it. And anyway, I'm really glad you got the book. Look, I got, I was studying up to do the show and introduce Ed. Really isn't much I could say about Ed, except he's done a job for the industry that people don't realize. In the last few years, he's a little bit more high profile because of his role with the advocacy with the RAA. Yep. But he's been out there for years. Although he primarily operates in California and a few other states, he's really been a national figure, and through his standardized contracts and all of that, he's helped the industry immeasurably. Now, so I have a book. Okay. There we go. Yeah, and I love all these idiots guides and the dummies books. Now everything is digital and whatnot. But I use this in my project management training that I do, and it's really good for any business owner. So I'm going to read two definitions. One of them is going to really be the setup for the show, and the other one will be something Ed may or may not address. Actually, John, I already emailed Ed this morning and some comments on his book, and I gave ideas for the second edition and for the next podcast show, and I'll close in a minute, and then you'll bring Ed on. But there's a definition here called the meeting of the minds. And I learned this with Ed and many other lawyers early in the day. And this is the legal definition according to this book of meeting of the minds. A meeting of the minds is when the parties to a contract have the same understanding of the terms of the contract. This must occur for a contract to be valid. And Ed's going to build on that. In my mind, this show, that's the macro. How do people in the restoration triangle, you didn't talk about that, I'll leave that to you, John. How do the people, the contractors, the property owners, and people involved in the claim, and then the insurance company, how do they have this meeting of the minds to get to an agreement, to agree on scope and pricing and timelines, etc.? That's the key. The AOB is a hot issue, an important issue, but in my mind, it's kind of the micro issue of the larger issue of the meeting of the minds. The other thing, Ed, and I didn't see this in there. You had the irrevocable rights and all that, and I'm saving some of this stuff for the wrap up on the show. But here's another definition which is huge, and I don't know if you're going to cover it or not, but I'm going to bring it up right out of the gate. And it's called unjust enrichment. Unjust enrichment is a benefit that is incurred to one person either by mistake, chance, or someone's misfortune, yet that person refused to pay. And Ed may address it, and then we'll talk about it a little bit later. Those are two important terms that I think all restorers should know and understand, and certainly everybody that's on your show. John, I appreciate it so much. It was just a coincidence I happened to be here for the first, your first anniversary show. I'm really sometimes coincidence or not, but anyway, yep. Appreciate that. I'm calling in live from Southwest Florida. That's on the beautiful Gulf Coast in Naples, Bonita Springs. And I got my old signage in the back over my head, and Ed may remember that as the original pricing programs in the 90s under the Restoration Pathfinder, the logo and trademark that I have. I still have it, but don't really use it much anymore. But that Yahoo comment you made goes way back when there were two choices. You either paid for AOL or you had Yahoo or Hotmail. Didn't know what Hotmail was, and they were owned by Microsoft, but they asked so many questions. I said, I don't want to go with them. Yahoo's done a great. I actually have a Gmail account. I've had it for years. I don't give it to anybody. I get a little bit of spam in there, not much. But the time that you're going to spend with Ed, any time you can spend with Ed, is just you can't put a price on it. And I mean this from the bottom of my heart. And I will tell you this: since you told a little story about Michelle and the intentional restorer. I was chatting with Ed several years ago. The very first time, Ed, after that WRT class that you talked about in his comments, he was at a program I was doing for the University of Tulsa. It was in California, and we were talking to that audience of government people, and Ed happened to attend it. About midway through a sentence, there's 100 people in there. He stops me. He says, Pete, he goes, that's not what you said the last time I heard you speak. I said, really? And what I say? He's on his computer. He goes like this. And he said, this is what you said. He had it in his computer. And I thought about it. And I go, you're right. I did say that. This is what I mean now. He goes, okay. What's the moral of that story? Be careful what you say at all times, and particularly around attorneys, because they keep track of these things. You never know what can come back to get you. And Marty King used to say this in the early days of the CR program. Every professional restorer should know and how they say things in certain manners, and be consistent. And why? So that when you're misquoted, you can very vigorously deny. That is something I never would have said. And this is what professional people like attorneys and doctors, accountants, they learn those skills very early in their career. It's part of their career. Yeah. So I never forgot that. Several years later, when Ed moved from the plaintiff's, arena more into the restoration, one day we're just talking. I said, Ed, yeah, you're like the restoration lawyer now. You're this is what you do, and I help with some of the clients. A half hour later in my inbox, the artwork and the trademark patent pops up, and Ed goes, hey, Pete, review this and sign off. That is a true story, and it's the birth of the restoration lawyer. And without any further ado, I'm going to turn it back to you, and I yield the floor there, Mr. Intentional Restorer, and to my good friend from Palm Springs calling in live, the restoration lawyer. I'll see you all back at the wrap-up.
Thank you, Ed, or thank you, Pete.
Thank you, Brother Pete.
All right, Ed, you're back for the birthday bash. We planned this, right? I mean,
and what a great time! Fantastic thing, John. I really got to hand it to you. What you have done, creating your whole persona and this show and Pro versus Joe and everything else. You've done a fantastic job. You've helped to really expose a lot of young guns to some important issues here. It's really vital that the up and comers in the industry be able to understand some of these points, and the way that you've delivered it so creatively. You've done a fantastic job. And ladies and gentlemen, I am really happy to be here today, not just with Brother Pete, but with John Isaacson, the hardest working man in restoration infotainment.
Yeah, maybe there. Yeah. Well, and I hope people understand what I'm excited about too with Pete coming on and yourself is we've got this wealth of knowledge, right? Like IAQ radio every time is like drinking from a fire hose, right? You got the big guys that have tested, tried, been to court, those kinds of things. And we've got the new guys. And so I hope no one sees us as in competition with IAQ radio, but maybe the primer. We're junior high, they're high school, or they're college, we're junior high. So, you've been a great bridge. You've helped me reach out, and Pete as well. It's been a fun process of kind of maybe earning my stripes, hopefully.
You've earned them.
So Pete brought up, like he talked about, that was from IE Connections in October, the restoration triangle, right? Which is what all restorers are part of. You got and the way he puts it is who's damaged, who's fixing it, and who's paying for it. And so you started out, if people want to hear more about this, we covered that at length in our prior interview. You started out covering the who's damaged, right? You were working with the clients.
Right, yeah. Owners and occupants of water damaged buildings.
And in particular, some that had been harmed maybe by poor performance by contractors, right? That was kind of...
Yeah, we had cases against restorers.
And people started inviting you, hey, we're getting sued. Can you help us maybe not get sued, right? And then... Yeah. So you transition into working directly with contractors. You are the restoration lawyer, so dubbed, right?
At least according to Pete.
Well, I think the proof's in the pudding, right? I mean, you've been talk about not all of it is stuff that you could talk about, but contractors get sued, and sometimes it's like Pete talked about, the meeting of the minds. Maybe that conversation wasn't set up properly at the beginning. Something happened in the middle, or as Bob Packrell, very humorously points out, when you go to collect from time to time, clients are like, this is a pretty big check, right?
Right.
So, and that's, like Pete said, casting this in the broader perspective of what are the resources available for contractors to protect themselves, ensure they get paid for the work that they've done. And then obviously some of the way these things have been branded. So can we talk briefly, you had mentioned that, because I was digging in pretty hard in the prep on the importance of contracts. And you said subpar contractors with subpar contracts get paid all the time for subpar work, right? And so the contract isn't the silver bullet. It's not like you have this beautiful contract and that's the end of the story, right? So as we lead up to talking about assignment of benefits, how do you see the role of the contract?
Well, it's incredibly important. It's part of the puzzle, along with the AOB and the good quality workmanship. When we're talking about liability questions, I think the most important part is to just maintain a relationship of trust and open communication with the customer. Contracts are really often overlooked by this industry, unfortunately. And some states have taken a pretty aggressive role toward this. Like, for example, California says, you really got to spell out everything and get it all in writing before you begin any work. And that helps to achieve a meeting of the minds. When you go to court to sue on a contract, typically you don't have to literally prove that there was a meeting of the minds. You've got a written contract, and that will generally supersede any oral conversations that took place before it. But it's a good business practice to have a meeting of the minds, because we don't want our customers to be surprised. We don't want to give people sticker shock. And so in a perfect scenario, we would explain to the customer the basics of what we're going to do, when we're going to do it, how we're going to do it, and what it's going to cost, and then go over some of the key legal points like an assignment of benefits, mechanics lien rights, those sorts of things, so that when the contract is presented to the customer, they're seeing something that's already familiar to them. Yeah, he told me this, he told me that, and then they sign it.
Well, so just to, and that was part of the conversation we had. I mean, we're in 2021, we're modern restorers, right? And we still have people that are operating just with work authorizations, maybe not a contract, those kinds of things. What does that look like? I've always believed when you have a bad experience, and again, I'm plugging this because I'm excited I got it, but when you have a bad experience with a client, right? That should inform all of your processes moving forward. If you prepare your processes for your worst clients, learn from that experience, then in theory, you can kind of shorten that learning curve, shorten the pain points moving forward, right? So what does that look like when a contractor goes to court and they have a crappy contract? What does that look like to a lawyer on the other side?
Yeah, so it really leaves us vulnerable in so many different areas. It makes it very difficult to get paid. So, for example, the traditional restoration work authorization says that the restorer is going to return the property to its pre-loss condition, and that the customer is instructing the insurance company to name the restorer on the check. It doesn't explain the scope. It doesn't explain the price. So if the contractor is trying to go to court to enforce that contract and a right to payment, the judge looks at the contract and says, I don't see that this is even a contract. A work authorization in many cases is not a contract at all, because it lacks the material terms of the agreement. Contracts need to be reasonably definite. And so I like to say that doing a restoration project with a traditional work authorization is kind of like trying to play tackle football with sandals on. You can do it, but it's probably not going to turn out very well.
Especially if the other side's wearing metal cleats, right? You know. So we got the contracts, the standards of care. You've been involved with the standards of care, the revisions, and helping make sure that the terminology, holds up and those kinds of things. So how do those standards of care, I think everybody knows, right? You send your technicians and whatnot off to get certified. A lot of owners get certified. But then from a legal standpoint, what do those standards of care look like, as far as ensuring you're getting paid? Almost all contracts, if you have one, reference them in some way or another, right?
Yes. So when we're talking about standards of care, typically what we're referring to is workmanship and methodology as opposed to payment issues. And the basic concept, if I could kind of summarize the law of a whole bunch of different states all at once, is that the standard of care is practices that are common among reasonably prudent members of the trade who are recognized as qualified and competent. And I recommended to IICRC that goes into the standards, and it did in fact go into the standards. So when a company does not perform according to that level, which is basically the level that the good companies in that market perform to, well, then the contractor is potentially liable for the tort of negligence, which basically means sloppiness that caused somebody some harm. While we're talking about contracts and standards of care, there's one mistake I see fairly frequently in restoration contracts where the restorer, with the very best of intentions, says, we're going to perform this work according to the IICRC standards of care. All right. IICRC has put out some incredibly valuable, very important, very, very high quality consensus documents, many with ANSI accreditation. But as a matter of risk management, we don't want to commit ourselves to every single thing that's in those books in our contract. Okay. Yeah. And most restorers haven't memorized everything that's in those hundreds and hundreds of pages of very technical information. What we will do is we'll perform the work according to the standard of care without committing ourselves to one specific document that's so broad like that. Yeah. And when I was involved in the editing of the first edition of the S500 water standard, we were, in other words, preparing the second edition. I was listening to the committee talk, and every time somebody came up with an idea for something to put into the book, somebody else was able to come up with an exception to that. And I'm thinking about this, and I said, you know what, let's put something in there that says that it's really not feasible to write a standard that applies to every single conceivable scenario. All right, what we have in those books is a number of very, very helpful general principles, but I suggested, and IICRC agreed, to put something in there that says that common sense should prevail in all cases, and that in extenuating circumstances, deviation from what's written in the IICRC standards may in fact be appropriate. And that's a kind of issue that I have a feeling is going to come up with some of this work that has happened this year in the state of Texas on kind of a triage basis. Yeah. And, what exactly is the role of the IICRC standards? No court or legislature has ever said IICRC is the law. Okay, it's evidence of what the standard of care is. Yeah. All right. But if somebody gets themselves backed into a corner, and sometimes I have this when I'm defending restorers, where we didn't do exactly what it says in the book, then we go to the escape hatch that's in the inside front cover that says, in extenuating circumstances, deviation from the standard may be appropriate.
Well, and that's important to remember too, is it's a consensus document, right? So that's, the things that are in those standards are what we can agree to, across the industry. So it's, a guideline. And like you said, you've got common sense has to prevail. You have to apply it in the unique scenario that you're in each of those cases.
That's it.
Okay. So I think, is there anything else? I'm going to go to a quick ad break, but is there anything else we need to, before we go specifically into AOB, anything else that you think is pertinent as far as laying the groundwork for contract standards of care leading into securing your money and the resource of AOB?
I mean, I want to encourage everybody to make sure that your contracts are updated regularly, that they're reviewed by a lawyer who's licensed in each jurisdiction where you're going to be doing the work. And, there's more to a contract than just legal terms. You want to have provisions in there that deal with what's happening in the industry, the business factors of all this. And this is how I work with contractors who are outside the states where I'm licensed. We collaborate on the business aspects of it, like with the insurance payments, as a matter of fact. And then they will send that on to a local lawyer to make sure it complies with local law. And the very best way, in my humble opinion, to stay abreast of what's happening in the industry is to join the Restoration Industry Association. It's the industry's largest, oldest, and best funded trade association. And it has an advocacy and government affairs committee where we are actively and aggressively pursuing a fair and level playing field for restoration contractors. And I want to encourage everybody to attend the 75th anniversary, the Diamond Anniversary celebration convention that RIA is having this June down in Florida. It's going to be a great time. We're going to be together in person. It's going to be safe. It's going to be distant. It's going to be a fantastic event to get together again in person. And you can sign up for that at restorationindustry.org. Please join the movement. RIA is doing extraordinary work right now.
Awesome. All right. We're gonna pay some bills and then we'll be right back.
Pay the bills.
Do you feel like you live in a world where everyone and everything is hitting you all at the same time with their urgent demands?
In a word, chaos.
What does an intentional restorer do to keep themselves organized and their upward mobility on the tracks? Friends, it's time to calm the chaos, get your team organized, and focus where it matters, growing your business. I Restore IO, the restoration company management software from iRestore, powering your vision, values, and leadership. Request a demo. Here's the features. We got job management, relationship management, aka CRM, equipment management, vehicle management, human resources, and scheduling. Request a demo. All you gotta do is click, no obligation. Check it out.
You follow all instructions and you save and forget.
iRestore. Don't just take our word for it or iRestore's word for it. Here's a customer review. As a small business owner in a unique industry, I am glad we chose iRestore for our go-to project management system. Their team has been great with understanding our needs and providing prompt customer service. I love having direct contacts when I need them and the same support staff to work with. Being able to ask for little changes that allow our processes to work within the system has been great instead of having to adapt to a system's processes. iRestore. Are we live?
I can't do it.
We're live? Oh, okay, we're live.
Okay. We'll do it live. Okay.
Yeah, you might be noticing new prop, right? And you can see the orb light in my eye receptacles.
Do it live. I'll write it and we'll do it live.
So people are asking, John, intentional restorer guy, why are you wearing such cool shades? And I say, these things that I spent $20s of dollars on in my DYOJO podcast and book writing money at Be Intentional Culture at the local golf gift shop. These? Okay, stop. It's because I wear cool shades because we've been hanging out with some cool people, some cool cats.
He's the least cool guy I've ever met.
And one of the questions we've been asking, we met with 6 different entrepreneurs, business owners at various levels of their companies from all around the country, mostly restoration companies, one specifically just construction. And we asked them, what are some of the things, what are some of the benchmarks of growth, benchmarks of growth, where they hit a point they realized as a leader, as a company, as a leadership team, as an organization, they need to do something different to get to that next benchmark. So one of the questions, I reached out to all of them and asked, what was harder, making your first million or doubling it for the first time? So what's harder, making your first million or doubling it for the first time? Good question. But yeah, in this series of releases that will be sequential over the next few weeks, we've got Lisa Lavender, Gordy Powell, Tammy Berklid, Whitney Wiseman, O.P. Alvarez, and Andrew Golkin. Of course, your cool, your hip host, John Isaacson, the Intentional Restorer. As always, our cool kids, helping you shorten your dang learning curve. Thinking about growth and the different ways that people approach that. There's more than one way to skin a cat.
Honey?
Not 100% sure where that quote came from, because who's really all that into skinning cats anyways? And then where do these people meet to compare concepts for skinning said cats? But I digress. Oh, we gotta do what the cool kids do. Okay, so if you want to thank us, hit the subscribes, stuff, things, buy books, and spread the word. So thank you, you're welcome, and good night. And we're back. Oh, getting some reading in, Ed?
Yeah. Interesting stuff here. Thou canst not take too many photos.
Yeah.
Agreed. Documentation, important.
That holds up in court too, huh? That's all
I'll hold it up. Right there.
Okay. Drum roll. Let's get into the hot topic. So before, if no one hears anything other than this, right? You've got the book. It is called The Book on Assignment of Benefits by Ed Cross, the restoration lawyer. First draft is out and on your website. Ed, what is an assignment of benefits? And how is this a tool to be used for contractors?
An assignment of benefits is the transfer of legal title to rights under an insurance policy over to someone else who's performing a service. And just about everybody who's ever had medical insurance has signed an assignment of benefits and probably doesn't even remember it. If you have medical insurance and you go to a doctor, normally the doctor is going to have you sign an assignment that allows the doctor to bill the medical insurance company directly. And that's actually a convenience to the patient. I know when I get a bill in from a doctor, I just wait until the next statement comes through that shows what the insurance payment is. And it saves me the headache of trying to chase money from the insurance company. So when a contractor gets an assignment on an insurance claim, it allows them to step into the shoes of the policyholder and collect directly from the insurance company. And they are very poorly understood. They've got a bad rap. There's been a lot of controversy. There's been some legislation. And that's why I thought it was time to go ahead and put out a book on this. And the book explains the strategies. It explains some of the things that I've learned in the process. It includes my personal assignment of benefits, which I now call assignment of insurance rights, because it's much more than just an assignment of benefits. And it includes instructions on how to present it to a policyholder and how to present it to an insurance company, and then what to do if they don't pay on it. And so I'm very grateful again for the chance to be here today to talk to you about it, John.
So why is that? Why is it common and we don't really bat an eye when it comes to going to the doctor? Something, it doesn't matter if you go in to get your teeth cleaned or, your liver replaced. You're signing an agreement that if you die, it's not our fault, right? And so we're used to doing that at the doctor. We assign away our assignment of benefits for our bodies. But why is it cast so differently when it comes to our homes, which obviously are so much more important than life itself, right? So why is it cast in a different light?
At the end of the day, these things are really about impressions, if you asked me. And the impressions are driven very much by what is in the media and what the big corporations are talking about. And the critical difference that we have between medical and restoration is that the medical industry has a very powerful, very organized lobby. The medical industry is unified. The restoration industry has not been unified. And that's why the RIA formed the Advocacy and Government Affairs Committee to help unify the industry and put out information, consensus-based information about strategies that restorers can employ to help improve their businesses and achieve a fair result at the end of an insurance claims settlement negotiation. And I'm very excited to announce that in the near future, the RIA is going to be releasing a summary of the assignment of benefits law for every single state to its members only. This is just one of a huge plethora of members only benefits that are available from RIA. And this compendium of the law of all of the different states can be used as a great counterpart to a good assignment of benefits or an assignment of insurance rights form, because you can take the law from your state out of the RIA book and incorporate that into a letter to present it to the insurance company when you're handing over your assignment of benefits. And it's very, very important that there is a submission of the assignment to the insurance company. When a claim is submitted, that's called a tender in the world of insurance law. So we tender the assignment of benefits to the insurance company. We want to do this immediately. You get the assignment of benefits signed immediately, right with the contract. And the same day, you email it and certified mail it over to the insurance company to put them on notice of this and to begin this long process of trying to get them to understand that assignment of benefits are enforceable. And adjusters tend to be dismissive of this. They'll say, this is an agreement between you and the policyholder. It doesn't affect us. Wrong. It does affect them, because the policyholder, once a loss has occurred, has a right to collect benefits from the insurance company. That's like a personal property right. And the law of most states recognizes this. And this is a personal property right that can be sold and it can be transferred like you would sell or transfer an automobile. So my big goal for my law practice for 2021 is to help accelerate collections for restoration contractors. My goal in my capacity as restoration advocate for the RIA for 2021 is to get to a point where by the end of this year, adjusters, most of the adjusters at the major insurance companies will understand that assignments of benefits are valid, enforceable, and they need to be honored instead of being dismissed. When they dismiss them, and they go ahead and they send the money to the policyholder who runs off to Hawaii, then we go back to the insurance company. We say, you paid the wrong party and now you have to pay twice. And despite considerable resistance to that, we have successfully gotten a number of major insurance companies to pay a second time. They repay the same amount they've already paid because they realize after running it up the ladder to their legal department, we should have paid attention to that assignment of benefits. We paid the wrong party. Now the homeowner is sipping a Mai Tai on the beach in Waikiki. We can't find them, and we're liable for the difference. And so it's a very, very powerful tool. Not only that, it puts the restorer into the front seat to be able to negotiate with and work with the insurance company so the door doesn't get slammed in the restorer's face. Well, we don't have to talk to you. We don't have to explain. When the assignment is submitted to the insurance company, what I have in my form letters that are in the book, that's a cover letter that goes with this, is a demand that the insurance company send over a complete copy of the policy packet. They send over all of the correspondence that relates to this part of the claim. They send over copies of their comp bids. They basically send over the complete claims file because we step into a first party position as to that claim as if we were the insured and we're entitled to all of this information. And it's amazing once you actually have the information, all the different things that you can learn, and you find out, hey, as a matter of fact, we should get paid after all.
Yeah. Well, because that's the nightmare scenario, right? You have the contract, you do the work, insurance sends the money over, and not saying maybe everyone's an opportunist, but when large sums of money come in the mail, it certainly makes you think twice, right? And so, so this, and it does that because we've talked about previously, there's a fine line for contractors where you're stepping over the line of being a contractor, negotiating scope with the insurance company and acting as perhaps a public adjuster, those kinds of things. And you can get yourself into trouble that way. And that's brought up in some of these cases. Whereas if you have an assignment of benefits, you are now basically, what's that movie with Tom Hanks? I'm the captain now. You're dealing with me now, right? And so that is the assignment of benefits. In short, makes you the client, right? The contractor is now the client negotiating directly with the insurance company on the client's behalf as the client. Is that correct?
You step into the shoes of the policyholder, or the way the courts down in Texas call it, you step into the boots of the policyholder, and you're able to deal directly with the insurance company on that. And what I put into my assignment is an explicit waiver of the right to privacy, because some adjusters will sometimes say, we don't need to talk to the contractor because the details of this claim are private and it's private information of the policyholder, and we can't release that. So we have a waiver of the right to privacy as to the specific issue that the contractor is addressing. Keep in mind, the assignment doesn't apply to the whole claim. We're not asking for an assignment of additional living expenses or total loss contents. It's nothing like that. It's specific, it's narrow, and it's limited.
Well, in the private chat, John Lapatere brought up, don't overlook Medicare fraud. Does that in those instances, obviously there have been some bad actors, right? where has the overreach or some of the negative backlash towards contractors come from?
So everybody's got some different opinions on this, and all I can do is tell you what mine is.
Yeah.
There are a number of instances where people from every single industry, including the industry that I work in, where people are overstepping and committing bad acts. Okay. And the AGA is not here to represent the bad actors. We represent the contractors who play by the rules. All right. So there are contractors who sometimes overwork a project or overbill a project, or will sometimes categorize something as category 3 black water damage when really it's not. And this gets a lot of people really lathered up, and I understand that. And the contractors who are doing that are simultaneously operating under an assignment of benefits. But I don't think that the assignment of benefits is the problem any more than saying Ford is the problem because these bad actor contractors are driving F-150s.
Yeah. Okay. I got you. So obviously, the insurance companies and those that represent have kind of stacked against this. We shared some quotes. Security First Insurance said, an AOB agreement is legal, but sadly, they're often misused. The implication being by contractors, right? The insurance company pointing at the contractors. How is an AOB different from a direct payment agreement?
Yeah, that's a very good question. And a lot of people don't understand the difference. So contractors will call my office trying to collect on a bill. And the first question I ask is, do you have an assignment of benefits? They say yes, they send it over. And all the contract says is that the policyholder instructs the insurance company to send a check and to name the contractor on a check. Okay, that's a direction of payment, right? That's not an assignment of benefits. An assignment is a transfer of the legal title of the claim over to the recipient. And it's a lot more elaborate than that. And there's some special language in there that needs to be used in order to make the assignee the actual legal owner of that particular claim. And one of the big attacks against AOBs is that contractors use them to overcharge on their jobs, all right? Yeah. As if it completely handicaps the insurance adjuster, like the insurance adjuster can no longer adjust the claim. If the bill is too high, Mr. Adjuster, don't pay the amount that's too much. Right? The fact that the AOB is there, it doesn't suddenly deprive the insurance adjuster of the ability to look at a bill or look at a scope. If the work is excessive, if the bill is excessive, don't pay it. Don't blame it on the AOB.
Well, you brought up two things because we've been, some of the reasons some contractors do program work is it supposedly secures the money better. Insurance companies will say, well, if you're on the program, we can assign the check to you and the insured. We have had instances where our name's on it and the insured's on it, and somehow they're able to cash it without our signature, right, as a contractor. So that's a reality. Shouldn't be able to happen, which is an instance where the AOB, like you said, provides that layer of protection for the contractor. The other part of that is in the negotiation. I lost my train of thought here shortly, but so the AO. Can we
birthday
cut?
bashes are really something, aren't they?
Can we cut? Yeah.
You started your celebration early, didn't you, John?
Well, so that, I guess that's where I wanted to go. You typically, as a contractor, you arrive, right? You've done it for years and years and years. The homeowner is like, I don't know what I'm supposed to do. This is really frustrating. The implication is they want you to take over. They want you to deal with the insurance company directly. We had a quote from Harvey Levine Insurance. It means if you sign this AOB, here it is, right? You can't collect any of the payments from the insurance company. You can't even talk to them about the claim. You have signed your rights to the insured. entirely over to the contractor. So is that true? There's twofold. A lot of times that's what homeowners want, right? I don't want to deal with these guys. I would like you who is experienced to take it over. Like you said, we want to stipulate this is a tool for good contractors acting in good faith. Whereas if you're a bad actor acting in bad faith, it doesn't matter what the tool is, you're going to abuse it, right? So for those contractors who want to do things the right way, you are recommending this as a resource to secure your money. If I'm selling that to a client, are they signing away every right? They don't have the right to see any of the information. All of this is going on behind the scenes, and I'm not involved in my claim anymore, and I don't know what happened.
Yeah. I can tell by the way you asked the question, John, you already know the answer. And the answer is no, it's not like that. Has there ever been an assignment written somewhere that says that? I guess it's possible. I've never seen it, and I've reviewed over 500 of them. All right. Now, I've heard a lot of attacks on AOBs over the years, and to me, really most of them were not well-founded. Last week, for the very first time, I heard a new complaint that I had never heard before, which is that contractors in one particular market, a couple of them, were getting assignments executed and then trying to keep the customer from ever bringing in a new contractor. So let's say there's a falling out and they don't want to continue with that contractor. They want to bring in somebody else. I'm told, and I'm getting this second or third hand, that these contractors will say, well, you can't fire me because I own the claim. That is a misuse of the assignment of benefits. That's not the purpose of the assignment of benefits. And there are many circumstances where it's in the party's best interest to go their separate ways, whether there's been a falling out over workmanship or accounting issues or whatever it happens to be. You don't want to cancel your contract because then you're relinquishing your rights, arguably, under the contract. And sometimes people will say, all right, we're not going to work anymore for this particular customer, so we're going to sign a cancellation. You don't want to be subjected to an argument that you have waived your right to recover attorney's fees or late charges or any of those other kind of contract rights. You can terminate the services, and sometimes it's a good idea to terminate the services. And once that happens, don't try to sink your claws into the portion of the insurance proceeds for the work going forward after you're already off the job. That's not the point of it. I've never seen an assignment of benefits that says that the policyholder can no longer speak to the insurance company. I can totally believe that adjusters have pushed away policyholders and said, well, I can't talk to you because I've got to talk to the contractor. They can do both. All right. The policyholder shall be kept in the loop about the status of the claim. And, that's clear. And in my assignment, we make it very, very obvious who's doing what. The policyholder remains obligated under the policy to submit documentation. The contractor has the right, but not the obligation to participate in the appraisal process. And of course, the contractor does not assume the duties to pay insurance premiums. And sometimes you get a sarcastic adjuster saying, oh, well, if you've got the benefits under this, are you also going to assume the duties? No, it doesn't work that way. And why? What's the big difference? What's so important? The assignment is given as security. It's security that the contractor is taking in consideration for the fact that the contractor is going to commence services on the job without the assurance of immediate payment. When somebody's had a fire in their house, a lot of times they don't have the cash available to just write a check to have their house fixed. They need somebody to come in and get started on the job. And we want contractors to be able to do that work, to minimize the additional living expenses, to accelerate the project. And in order for them to be able to do that, we want to get started as quickly as possible. And if a contractor can get an assignment of the insurance rights, then the contractor has reasonable security that there will be payment for the services rendered so the work can go forward and these buildings don't lay unproductive for an extended period of time.
Would you, we try to make it, I've always, everywhere I've been, make it as transparent as possible. So anytime I'm emailing the adjuster, the customer is CC'd, and so that way, even when customers say, I don't want to be a part of the process, I want to make sure they see, things as they progress. So whether, even if you use an AOB, would you agree that that's good standard or practice? Is that helpful in the case that something goes to court? Contractor says, hey, at every point, we've kept the insured as informed as possible.
Sure. Yeah. Transparency is a good thing. And a lot of states really expect it, particularly when working on residential projects.
Yeah. Yeah. So it brings up that question of, who benefits, right? So everybody's pointing their fingers. The reason you want this, attorneys, the only reason attorneys want this is because that's how they make their money. You've got the contractors, carriers saying, the only reason contractors want it is they can, run the rates up and everything like that. So how does who benefits from this, and why do you believe it's an important tool?
Well, obviously, the most important person that we want to protect in the process is the policyholder. And like I mentioned, we want to make sure buildings get back online as quickly as possible. And an AOB can help to accelerate that process very much. I don't want to have to front the money to my doctor for him to perform a surgery on me. I want the insurance company to come in, take care of that, pay the doctor, and that actually helps me. It also obviously helps the contractor by providing security that there's going to be payment for services that are rendered. And since it allows the work to proceed more promptly, it helps to save ALE expenses on the part of the insurance company.
Well, in the medical regard too, right? Most of the time they usually give you an estimate. We believe insurance will cover this. We believe this will be our out-of-pocket expense. But in the event that we're wrong, it's all your responsibility. I guess there's a little bit of difference there in the medical where, maybe there's something life-threatening, because on the insurance side, like you said, buildings standing right now, insurance companies are busy. So they're with the recent events. So, sometimes claims take a little longer than people are comfortable with. So why though, I want to give homage, IAQ Radio, Pete facilitated a town hall conversation on AOB episode 553 shortly after Florida had their changes with the fee shifting. So AOB did not go away, and if I understand correctly, AOB did not go away. The fee shifting schedule for contractors went away, which is where you could recover lawyers' fees for the process. So I want to read a quote. I think this relates. This is, who is this from? The Insurance Information Institute. They said the state's David and Goliath law was meant to level the playing field between policyholders and economically powerful insurers. It lets plaintiffs' attorneys collect fees from the insurer if they win their case, but not vice versa. If the insurer wins, the plaintiff owes the insurer nothing. This creates an incentive for attorneys to file thousands of AOB-related suits because there's no limit on the fees they can collect and no risk. So the first part, the contractor and or client can recover their fees, but not vice versa. So this is a terrible imbalance. But if you rewind the tape, the reason the client is suing their insurance company is for lack of coverage for something they believe should have been covered, correct? I mean, that's where this comes into play.
Yeah, well, in this situation, what you're talking about is lawsuits by the contractor against the insurance company as opposed to the policyholder against the insurance company. And I'm really glad you brought this up because there was some bad things and some unusual things that happened in the state of Florida that kind of created a stigma around AOBs. Absolutely unique and extraordinary what happened there. It doesn't represent what's happening in the rest of the country. So the big issue there, like you mentioned, John, was attorney's fees. So let's talk about a basic principle at the outset. Normally, a party to a civil action must bear his or her own legal fees. Now, there are two exceptions in most states, which is that parties can agree as to who will pay attorney's fees by contract, or there can be a special statute that indicates when attorney's fees are going to get paid. And in the state of Florida, they had this really weird law for attorney's fees. And it said that a party could recover attorney's fees for the amount when they file a lawsuit to recover insurance policy benefits. All right, that was it. So contractors were signing contracts, they were getting AOBs, and they were filing lawsuits really, really fast. That's not the purpose of the law, but that's how it started to get used. And because Florida was extraordinarily liberal and said, you can get reimbursed for your attorney's fees just for recovering money on the policy by filing a lawsuit. That's totally different from how it is in the other states. Most states don't allow for the recovery of attorney's fees at all. Under any circumstances. California is kind of an outlier there. California says you can recover attorney's fees in an insurance bad faith case if you prove that a tort was committed. But it wasn't like that in the state of Florida. And news reports said that one particular lawyer filed 30,000 lawsuits in Florida in 1 year, and things were kind of going berserk and haywire. So naturally, the insurance industry came out and they were fighting this really, really hard. And they present this legislation to change Florida law. And of course, it's done in the interest of consumer protection. The insurance companies, they want to protect consumers. And I don't know if you believe that or not. I don't know if you take that seriously or not. To me, it sounds kind of like McDonald's saying that they want to protect cows. But be that as it may, the insurance industry says we've got to put a stop to this terrible thing. All right. They did not outlaw AOBs. What they did was they modified the attorney fee structure so that it's a sliding scale, and the contractor that's holding an AOB needs to substantially prevail on the case. And if the contractor doesn't do well, then the contractor has to pay the insurance company's fee. So it's now a two-way statute. And prior to the trial of a case, the insurance company has a right to make a settlement offer, and the contractor needs to beat that settlement offer at trial. And then there's a sliding scale under certain circumstances as to the attorney's fees that can be recovered there. But to me, the biggest problem here is that they added something in that said, if you get an assignment of benefits in the state of Florida, you are waiving the right to recover any money from your customer. And now all of a sudden, all you've got is the insurance company. Well, guess what? What if there is a policy exclusion? What happens if they didn't pay their premiums and there isn't any policy at all? I tell everybody, do not use an assignment of benefits in the state of Florida. And that's the only state where I recommend that. So we can't judge an entire legal concept of assignment by what happened in these really bizarre circumstances in the state of Florida that went from the absolute liberal extreme to a super conservative extreme at the opposite end of the spectrum.
Yeah, we have the tendency to respond to extremes with extremes, right? Well, and I maybe check you said the insurance companies have as much interest in protecting the consumer as McDonald's does in cows. I believe it's been documented that McDonald's uses fraction of actual beef. So maybe McDonald's actually has a better interest in protecting cows than insurance companies and clients. So, okay, so
only here on the DYOJO podcast, folks.
Only here. Okay, so these acts, right? We got Florida, California, Texas, Hawaii, Idaho, Iowa, Utah. All of these responses to AOB are popping up and pretty frequently, right? In a lot of them in relationship to what we're hearing out of Florida. But they're always cast as Insured Homeowners Protection Act. And that was most recently the one in Idaho that popped up. I know Mark brought that up. You've brought that up, RIA, AGA. What happened there? How was that? How was it cast, and what was the response, and what was the result?
The state of Idaho had a Senate bill pending, which gave a policyholder the right to cancel an assignment of benefits under certain circumstances. And one of them was where there was a coverage issue, for example. And I think this was partly in response to this concern that a contractor might try to hold a policyholder hostage with an assignment of benefits. And like I mentioned earlier, if the customer wants to terminate services, try to work with the customer to find a reasonable settlement to make that happen. In some states, if a contractor is wrongfully ejected from a project, the contractor would be entitled to the profit that the contractor would have earned had the contractor been able to complete that project. So just because your services get terminated does not necessarily mean that you don't earn your profit for the job. But I digress. The state of Idaho, with some heavy insurance emphasis behind it, presented this bill, and it was argued that policyholders should have the ability to cancel an assignment of benefits. Now, this is really, really unfair. If a contractor goes in and completely decontaminates a building in reliance on an assignment of benefits, and then the customer gets an opportunity to retroactively cancel that, that leaves the contractor without a reasonable remedy. It doesn't protect the contractor's reasonable expectations. And I'm very happy to say that bill in Idaho was defeated.
We hear contractors, some people are obviously against it. Obviously, a lot of contractors in Florida feel like it created, a negative impression with consumers. And that's even Merlin Law Group, who's respected by many for protecting the rights of the consumer. They noted bad actors, but it should protect consumers and preserve the ability of a policyholder to execute an AOB under the right conditions. So,
right.
Do you think an AOB should be used in every claim? And then two, even contractors that are maybe opposed to use of AOB, is it still important to, like in Idaho, uphold the rights for others to use it in instances where they see fit?
Yeah, it is really important to stand behind the right of a contractor to get an AOB. And when this issue comes up, the AGA is going to get behind it. And we hope everybody will help join in that particular effort. This is something that really affects our economy as a whole. When we're not able to, accelerate the restoration and remediation of buildings. I mean, it's very, very serious, particularly with these serious weather events that we've been having. And, one of the concerns is that contractors use AOBs to blindside customers with exorbitant bills. And, the issue there is unnecessary repairs. And my position is if a lack of transparency is the problem, then perhaps the law should focus on disclosures and that sort of thing, as opposed to an assignment of benefits. So to your question, John, anytime there is the possibility, the chance that there might be insurance coverage for particular work, I recommend to everyone outside the state of Florida that they go ahead and execute an assignment of benefits. And different states handle them in different ways. And something is really important that we have to point out is the issue with post-loss assignments of benefits. The reason these are enforceable in most states is because they are being executed after a loss has occurred. Why is that important? Well, many insurance policies, most insurance policies, contain an anti-assignment provision. That simply says that the policy cannot be assigned. Well, a lot of adjusters receive AOBs from contractors, and they say, we don't need to honor this because our policy prohibits it. Wrong. The policy prohibits assignment of the policy, not of a particular claim. And in the majority of jurisdictions across the United States, a post-loss assignment of benefits is valid and enforceable for the reasons I mentioned before, which is that once you have a claim, that's a right that you own. It's not a contingency, all right? It's actually a right that you own. Whereas if I were to assign an entire policy, then that would arguably change the insurance company's risk under the policy. So you don't have an assignment for the purpose of increasing the risk on the part of the insurance company in terms of the nature or the scope of the loss. But another reason this is so important is that policyholders don't have the resources to pursue claims against insurance companies when they underpay on a claim or they wrongfully deny coverage. Restoration contractors have more resources and are better equipped to be able to pursue these claims, which is why they are good parties to receive them and then pursue them. Nice.
And John Lapotaire been on there, and he agrees, that it is necessary. Don't throw the baby out with the bathwater. It's the AOB abuse that he strongly disagrees with. And as mentioned in that IAQ town hall, get a good contract, be transparent, communicate. So it's not like AOB excuses you from, hey, I can be a crappy contractor. I got the AOB. Let's rock and roll. You still got to follow standards of care and be transparent. And
the next time you hear somebody crying AOB abuse, take a very good look at it. Read the documents very carefully and figure out, is it AOB abuse that they're claiming, or is it price abuse or scope abuse or some other abuse that can be remedied somewhere else?
Right. Yeah, like, again, throwing the baby out with the bathwater. You have been more than generous with your time. We've got Pete waiting to come back on the line. As we wrap up, is there any other, I know I've still got billions of questions. I know you could probably talk about this for days and days. Any other closing comments that you think are important for restorers to understand about this topic?
It's really important that everybody do their best to come down to Florida in June for the RIA convention in Kissimmee. And we're going to be there. It's the 75th diamond anniversary. It's going to be a wonderful time. A lot of great people, including Brother Pete Consigli, my personal consigliere, is going to be there. Sign up now at restorationindustry.org.
And meet Ed in person and meet Pete in person. I'm planning on being there as well. So that's probably
bring your mask. If you're around me, bring your mask.
All right, Pete. So I wanted to Oscar Wilde. Most people know Oscar Wilde's quote, "Imitation is the sincerest form of flattery." I was surprised in looking that up. There's actually a second part to that quote, and it says, "Imitation is the sincerest form of flattery that mediocrity can pay to greatness." So as the mediocre assault on the audio, the eyes and ears of the property restoration industry, I want to pay homage to IAQ Radio. You consistently appear on that podcast, airs every Friday, 12 p.m. Eastern time. And your role there often is the industry watchdog to come in and make sure the information that was presented is both historically and practically accurate. Do you have any comments for us? Anything else that we missed?
Well, funny that you asked. Yeah.
Uh-oh. Here we go.
Uh-oh. No, listen. First of all, it was a great show. And I was tracking, and all the comments that I made really were to dovetail to the reinforcing comment and things that you made, but in a historical context. And so I first started out thinking I was going to have a logical way to do this. And then I got a yellow pad, and I said, let me organize these notes, but I didn't want to miss any of the show. And I said, you know what? I got to just be Pete. So whenever my time is on, I'm just going to be Pete, and I'm going to take them as they come, and it is what it is. So, so let me just start here. I wrote an article. Marty King in the mid-'80s presented at a conference in the old early days, different name for RIA, called The 4 Reasons a Customer Won't Pay the Bill. Now, you've addressed some of these. You addressed it, John. Ed addressed it. Bob Packrell addressed it. Now I'm going to tell you what Marty said. Marty said there's 4 reasons and 4 reasons only. He says the first reason is to have a legitimate complaint. If they have a legitimate complaint, let's take care of it and fix it. The second one is they think they have a complaint, but they're not sure. You know, maybe the paint isn't right, the quality of the carpet, whatever it is. Well, then you got to explain it. You got to fix it. You got to get them to be satisfied. And that's that. Now, here's number 3. And number 3 was one of the ones that John, you made a comment in Packarell's book right in the beginning of the show where Packarell said, well, sometimes the customer sees how big that check is, they want to sign it. That Marty said is point number 3. The customers see the size of the check and they actually don't think you earned the money. Well, you know, if I knew it was going to be $5,000 to just clean a little smoke up in the house, I would have taken that money and, you know, I could have had my house cleaning lady do it. Of course, that's not the case, but that's what they may think.
Yeah.
All right. You see how with these 4 points, each one's a little bit more progressively harder, right?
Yeah.
The first 2 are just solid left brain. The second 2, these are more right brain. They're emotional. Here's the 4th one. The 4th one is the customer's a crook. Now, when you're in the business, you get to see and know the signals.
Hopefully.
So, yeah, hopefully. Sometimes the reason that a contract has the out clause in it, and this dates back to construction contracts, home building contracts, remodeling contracts, a good contract should have an arrangement in there. If either party wants to get out, what are the rules of getting out? I'm not going to delve deeper into that, but, you know, I talked about that. So if the contract has that, then you already pre-agreed in the meeting of the minds what the rules are. In the event you have to end the contract. Sometimes it isn't just the customer wants out of the contract. Sometimes the contractor wants out of the contract. And the customer may want you out because, you know, oh, boy, they're setting me up. I'm going down a road I ain't liking, and it ain't going to be good for me. And the customer's the one who got you on the hook. You don't have them on the hook. Watch out for those guys.
We talk about all the time, the best time to fire a client is before the project even starts, right? You don't want
not so much. No. Okay. Let me say this. You don't turn down a job. You turn down bad customers. Yes. You can do any job, right?
Yeah.
But if you don't know that, don't execute the contract. If you think so, whatever. But when you're in a contract, if you see it's got to go, the best time to do it is while you're just in the emergency phase, and don't commit to the next part, which now you're going to be lower margins and much more difficult to please them. And so you try to wrap it up there and protect that money and you know, let them go somewhere else for the rest of the job. But I will say this. I wrote an article in the Cleaning and Restoration Magazine on this, and John, you may have it in your resources, in Marty's Restoration Corner. This was after he passed. A number of the members are writing, and I wrote about that. Now, what happened is a bunch of it got edited, So what I have, and I may have sent it to you, and if not, it'll be in a future Dropbox resource, Watchdog style link. I have the pre-publication copies because I always keep pre-publication copies of stuff because I jointly own the copyright because they're not paid for it. So I'm not going to have some editor or publisher say, well, I can't use it. I say, no. You want to pay me for it, you own it. If I volunteer it, we'll jointly own it. I wrote a story in there that wasn't in the article, and it was a California story. It was somebody that Ed knows well, a good friend. And what happened was California, every few years, they do these public service announcements called amnesty law. They say, contractors, a lot of you guys, you're not licensed and you're violating the law in the state. And we'd like you to just kind of come in and just, we're going to give you a free pass. I don't know if they're still doing this, Ed. And just as long as you qualify, fill these rules out, and we want you to be a legal contractor. And the reason they do that, partly, I think, is they want the fees. But that's neither here nor there. So what happened is, a friend of ours, mine and Ed's, he did a small job. It was less than $2,000, and he had everything done. It was done, and anyway, the customer wouldn't answer. So one day, he decided, just out of the blue, he's going to go to the customer's house because he knew the customer had the check. All right, the adjuster said he's got the check. He goes to the house, knocks on the door. Oh, how you doing, sir? Mr. Contractor, won't say his name, and he goes, hey, how you doing? Hey, good. I'm glad you stopped by. I was just in the neighborhood. He goes, now I understand, you have the check. And did we do something wrong? He said, no, you did a wonderful job. He said, matter of fact, terrific. I'm very satisfied. So how come you're not going to pay us? He looked at me, he goes, because I don't have to.
Oof.
Really? He says, why? He says, well, the customer was an electrical contractor. So I'm a contractor in the state of California. He says, you did work that under state law, I don't have to pay you because you're not licensed to do that work. He says, I'm not doing this because I want to beat you out of that money. I'm doing that because as a licensed contractor, I don't like it when unlicensed contractor compete. It's not fair. My friend looked at him and he said, thank you. He said, that is the cheapest lesson that I ever had, because that could have been a really big job and he could have been taken down the road. What he did after that, he got in line to become licensed, and a lot of people do that. And that's something that's been in the code of ethics that Marty has talked about for years with the restoration companies. Make sure that you're properly licensed in the jurisdiction where you do business to operate. And in California in particular, and Ed knows this, but there's 11 Western states with very similar laws. The exam to be a general contractor, essentially, there's all kinds of questions in there that have nothing to do about the specific trade that you're in. Those are called the specialty licenses. If you're painting, I know about painting, electrical, plumbing, etc. It's designed to protect the consumer and to protect employees. You got to know about lien laws. You got to know about all that kind of stuff. And they get you all psyched up so that the licensed guys turn the unlicensed guys in. Because in the state of California, unless it's changed, you got to have certain size and point size. You got to list your contract number. It's got to be on your vehicles. It's got to be on everything that you do, or else you're in violation of law. And I think Washington, Nevada, there's a bunch of Western states the same way. All right, I'm not going to go any further because I don't want to say, hey, Pete, hold on, you're not a lawyer. You're right, I'm not a lawyer. But I had a very good insurance adjuster friend of mine. He said, Pete, well, you're a Philadelphia lawyer, but that's just a joke. He goes, you know what you are? He says, you're a risk manager, and you don't need to be licensed to manage risk. I'm very careful. I know exactly what I said because Marty told me that. I don't step over the line. I try not to anyway. And if I have Brother Ed on here, he'll be my CYA guy. RAA developed some standardized contracts years ago. And quite frankly, most of the information in there was donated by members who were Ed Cross guys. And most of that stuff is stuff that Ed helped put together. And nobody will know it, but they know it now. And it's influenced generations of people. And actually, Ed, what you said, some of the work you're working on are going to be member-only benefit. When RAA rolled that out, that was it was free to members, members only. You had to go to the online bookstore, put your member thing, you could download it. It was designed to then take it, use it as a model, go to the local a lawyer in your jurisdiction who can then match it to the local statutes, point size, language, verbiage, etc. These are guys who they deal in contract law. Their clients are builders and construction people. That's exactly what Ed's talking about. And Ed, over the years, knows how to find these guys in the state. If you don't have one, it's not your corporate lawyer that set up your business account. Normally, they don't know about this kind of stuff. And then he can assist, and he's done that. And Ed and we've done that and helped a lot of companies do it. So anyway, the other thing that I have is, in that restoration triangle thing, and these are some of the stuff you guys touched on it, but I think this is important. I want to make this very clear for your audience. In my article on the triangle and the IE connections years ago, I always said that price is often misunderstood. It's not line item pricing that people have issues with. Very rarely. It's always scope. If one guy says we can clean all the walls, and the other guy says we got to paint the whole house, then it's not how much you charge to clean walls or paint. It's, well, what do we need to do? So therefore, the first thing that must be agreed upon, if you want to have a meeting of the minds, is you need to agree on the degree of damage. All right? What level of water loss, what degree of smoke, whatever it is. You got to agree on that first. One guy says it's a category 2 or 1 and the other says it's a 3, then don't start writing estimates yet. Once you agree on that, then you can start agreeing on the scope, what needs to be done. Then you develop an estimate based on agreement so far. You say, we're going down this road for the meeting of the minds. Once you now have done that estimate, then you got to deal with the variables in the estimate so they're comparable. Number one are timelines and other little nuances like that. Some people basically say, well, and then you say, well, how long do you take to do that job? You're cheaper. Well, the guy's going to stretch it out. And the other guy says, we're going to turn around. Well, that impacts the decision, doesn't it? Yeah. All right. Because time is money. And the final thing that people never talk about, and this is nebulous and this is esoteric, but any professional restorer knows. How do you know when the customer's being satisfied? You ever ask them? They don't even know how to answer the question. Yeah. This is an entirely different deal. But you got to find out what's important to the customer that will put them at ease and that they'll know they're going to sign the job off. You got, in other words, what's their goal line? Not what you think the goal line of the adjuster does. What's theirs? And a big fire loss. Some of you guys have done the contents. Maybe start right out of the gate. Customer says, well, that little teddy bear, I'd like to get that cleaned and right away from my daughter so she can sleep in a little hotel or property. And, I got to get some suits. My husband has to go to work. Well, you know what? You get on that with the dry cleaning. You get that back right away. You're off and running on the right foot. That's simple. And then you kind of go from there. So those are very important points. Now, one of the things you guys were talking about standards. First of all, the word agreement usually is the same as a contract. But I understood, somebody told me, very reliable, Ed, in the state of Louisiana, it's not. You can't use the word agreement. So there are state issues. But generally speaking, guys like to use the word agreement. You know why? It's not as frightening as the word contract. You're on a contract. You're signing your life away here, right? If we have an agreement, it's a contract in most states. Marty told us for years, and I'm going to give it in simple forms. 2 parties to the agreement or the contract. You got to determine, who the 2 parties, make sure you have the 2 legal parties to the contract. Then you got to determine the scope of work based on what I talked about. Then you have to determine how much is it going to cost. Ed has a whole conversation to give on this. I'm not going to get into too much depth, but this is an important part of a contract. And then you have to execute the contract so each party gets a copy. Back in the old days, before the digital age, there were oral contracts, there were written contracts, there's also implied contracts, which was this whole thing with the unjust enrichment. And I'm going to close the show with that, if you bear with me. All right. So these are the things which go down the track to create the meeting of mind. One of the things that Ed always said, but he didn't say today, is if you get one of these boilerplate forms with all the language that complies with everything, and it's just 2 signatures, and that gets contested, as the contractor, you're on the low end of that, usually in the court's opinion, because you have an advantage to somebody who executed this at 2 o'clock in the morning where they're standing knee deep in the water. If that contract's all marked up in initial little things like that, that shows a meeting of the mind. That's a contract that will normally hold up when the homeowner, if they try to rip you off, the judge is going to think, I don't know, Mrs. Jones, is that your initial? Well, yes, it is. Did you talk about that? And you made a little change. Yes, it is. Well, now, didn't he do that? Well, I guess he did. Well, then you really owe him the money, don't you? Well, I guess I do. Thank you. Have a nice day. Next case. So think about that. Okay. The one thing that Ed brought up, which is huge, and one of our good friends, Peter Serkin, very well known in California, he always talked about this when he talks about guidance documents. The last thing you want to have, if you're in a deposition because you get into some suit, is some lawyer holding one document, whether it's S500 or 20, whatever it is, and beating you over the head with that thing. Well, Mr. Jones, Mr. Isaacson, let me ask you a question here. Now, did your technicians do that line and that line? Is that what you're saying you agreed to? This is why you say, well, we have a variety of documents, of which the IICRC standard is one of them. But there are EPA documents, there's OSHA documents in Canada, Australia, in the UK, they have their documents. We use guidance documents and a variety of documents to determine what the scope, what the risk, and the advice they're going to get the customer. So heed that. Now, Ed wrote a paper years ago. I thought we can't find it. He wrote a thing in 8 words that you shouldn't use. And I was going to say 8 words that you should never use, but never was one of the words you shouldn't use. And what you shouldn't use definitive terms. In other words, any, all, never, things like this. Those things will get you into trouble, and you're giving them the plaintiff's attorney the rope. All right. I'll tell you another word that you shouldn't use. The most misused word in the restoration industry is the word clean. What does that mean? Clean? What do you mean clean? Write your things that are process driven. Instead of saying we're going to clean the wall, say we're going to prepare the wall for paint. All right. We're going to wash the wall. We're going to scrub the floor. We're going to rinse it. Don't say I clean the floor. So much a square foot. Marty taught a lesson years ago where a customer taught him early in his career. She was wonderful with the job. This always happens when you're ready to sign the check. You're going to sign the check. This is Mr. King. He stopped by the house afterwards. I don't know why this is. You can't make this up. They always stop by the house at the end of the day with the check. You want to sign a check off. The lady says, well, Mr. King, your people did a wonderful job, but I have a problem in the basement. Well, show me, Mrs. Jones. We go down to the basement. He says, you see the floor? He says, yes. He goes, well, you on your estimate said you're going to clean it. It's not clean. Well, what do you mean? They scrubbed it. She said, they may have done all that, but it's not clean. He said, hold on. She goes to the bathroom. She gets some Ajax, a little water. She puts it on the floor with a toothbrush. She goes like that. There's a white spot. She says, that's clean. Now, if that's the clean that she wanted, this is about customer expectations, maybe you ought to charge by the square inch and not the square foot. And you're going to have, cruel people on their hands and knees to get the floor and see if the adjuster will sign off on that. Of course, if they have a Chubb or an HO6 policy, they usually will sign off on that kind of stuff. But if not, who knows? What do you mean? We're not paying for that. We're paying for industry normal kind of clean. Well, you can't define it. That's between the adjuster and the property owner, not you. Be careful that you don't use words like clean. Be more descriptive. I'll tell you one other thing. So here are the 3 parts, the legal terms to have a meeting in the mind and execute a contract. And here they are. And I wrote them down because I don't want to misquote them because I'm going into your territory here, Ed. But, this is stuff that you wrote and that David Governo and Michael Bout and the other attorneys have been teaching the WLS and the risk management and the property management stuff with Mickey Lee forever, wrote this stuff for contractors. And it's non-legalese term, but here are the legal terms. A contract has 3 components. You have an offer, you have acceptance, and you have consideration. Those things that I kind of told you in the rudimentary way Marty said it, that's essentially those things. In other words, the offer is what you're going to do. Acceptance, they agree to it, which means you got to have scope and price. And then, the consideration is the price. But you could also exchange something of value like bartering. That's a legal contract too. It doesn't have to physically be money. So keep that in mind. That's in the most purest and rudimentary things. I'll tell you another thing that Ed said this, and John, you may have said this about guys building sustainable businesses. This is a big thing with the AGA. This is a big movement. Mark Springer has been on your show, and mergers and acquisitions. He's been talking about this openly for years. When he wrote the article, The Greatest Need, which started the movement, he said, we have to build a sustainable business. We can't have these arguments and these fights with the TPAs, the TPCs, the insurance companies. We just can't have that. We got to regulate as an industry, and we got to do the right thing. Not do the right thing. Do what's right. There is a difference. And basically, how do you do that? Well, several years ago, I asked one of the big 3, I call them, in the state of California, and I don't know if this is still true. 3 insurance companies have 50% of all the registered policies in California. This goes back a ways. Maybe it's changed, but I can tell you who they are. And as of my research, which might not be totally accurate, but I ain't going to be that far off, State Farm at 25%. And Allstate and Farmers were 12 and 13. So if you're a contractor in the state of California and you got all 3 of those companies that are kind of mad at you, it's not that easy to do business, Try to at least have one of them who likes you. So anyway, one of the big 3 at one point, someone pretty high up in the food chain, I asked them many, many years ago, I said, if you got to give me a message, if it's E.F. Hutton, you'll have to explain to your audience that E.F. Hutton is listening. This goes way back. Ed knows who E.F. Hutton is. what would it be? And they said, Pete, thing I would tell you and your RA members and the IICRC certified, all these people, tell them to build better businesses and sustainable businesses. He said, then we can talk with you as an industry. He says, one of the reasons a lot of the middlemen is that we were fragmented. Couldn't talk to us. They couldn't talk to us like they could talk to the collision industry and other industries that have consolidated, right? Said, if your guys do that, which is a road we're on, the industry's consolidating. He said, now we can talk with you. And maybe one day there won't be that many middlemen involved. I don't know, because the more middlemen, the tougher the price, the more people have their hand in the pie. Two parties in the restoration triangle can directly deal without middlemen. It's better for everybody, isn't it? You just think about that. Now, I may have some people who heard me say that who may say, hey, Pete, we didn't like you saying that. No, that's because they're middlemen, and I like some of these guys. They're my friends, but that's business. I mean, travel agents don't sell tickets on an airline anymore. They had to find some other business. Nobody uses a fax machine. I could keep going with these. So you got to kind of move on with this stuff. Now, John, it's funny that you brought up this thing about your name being on a check and they cashed it. Did I have that? Anyone who's been around has had all these things happen. Yes, I did. We had one of the big three. We had a check. It was a small loss, only a couple grand. And we called the adjuster. The adjuster said, hey, name the it went to the insured. Our name was on it. You know what happened? He said, well, according to our records, the check's been cashed. I had to call the agent. The agent was a good friend of ours. This is in the Bay Area. And the agent said, oh, yeah, it was cashed. I said, so did you know that your client is a crook?
Yeah.
They forged our name and took the money. He goes, uh-oh. Well, what happened was, did I press her to do anything? No. You know why? A couple of grand. The adjuster said, Pete, if you do something about it, I'll go through the ranks. We'll pay you. He said, you really don't want to do it? I said, I don't want to do that. I said, because I'm going to get more business from you. I said, and the agent, they were so guilty. The amount of work they gave us, man, you know, I had the best $2,000 that I ever just waived. But I learned from there, you got to be careful about that. We always want to control the check. We want the check to come out. We don't actually care many times if the customer's name is on there because it makes them feel comfortable. And if we don't do a good job, we ain't going to get that check signed anyway. And if we do a bad job and we take the money, it's going to be a problem. So it makes the company feel comfortable as long as we can control it. Now, you think you have...
Is that what you mean by unjust enrichment?
Well, yes. So a little bit. Let me deal with that at the very end. I'm going to explain that. But let me now lend to another point that Ed talked about. All right. If you think you have trouble collecting money from an insurance company, you try getting money from a mortgage company. You try getting money from Bank of America, Wells Fargo, and these things who hold that. As a matter of fact, one of the executive directors years ago of REA wrote an article in the magazine because the mortgage companies were basically putting restoration contract as a business by essentially taking their money. I'll tell you why that happened in a minute. And what they said was, well, look, if you guys are going to take the money of our members, we may have all of our members take all their big truck mount units with all the water extracted from your clients' businesses, and we're going to come down to your corporate headquarters, open it up, and we're going to give you all the water back in your lot. Now, I can't believe that the lawyers at the time actually let him publish that, but he did put it in. We kind of got a little kick out of it. Of course, that wasn't really going to happen. Should contractors know and understand insurance policies? Yes. Are they insurance adjusters? No. Should they be? No. Nobody likes an insurance adjuster who was a contractor who wants to tell you your job. That ain't his job anymore. You know, like Springer always says, we'll stay in our lanes, we'll stay in our buckets. All right? Don't ever forget that. If you're a contractor, be a contractor. If you were an insurance guy working for a contracting company, be a contractor, etc. Ed York, who was one of the grandfathers of the industry, and he created the IICRC, DKI, and a number of other organizations in the industry. But back in the early days of the DKI, there was a 3-day orientation program that started if you were going to come under that brand. And during those 3 days, it's like a minuscule of franchise training, which is normally 2 to 3 weeks. It's 2 to 3 days. He had 2 days on process and branding, but he had one day that was called the RCR Day. That stood for the Restoration Contractor of Record. And he basically took an entire day to go through an insurance policy to educate people on the language. But this is before we had the restoration lawyer and people like that. He wasn't trying to teach people how to be insurance guys. He was just saying, this is what's happening. So why is that important? Because that lends to what the purpose of the AOB and what Ed said. When someone's standing knee deep in water, you got an advantage over them. You got to be careful, and you should be ethical, because Marty always said back in the day, you find people a very vulnerable time, and they can be taken advantage of, and oftentimes they are. Now, but you want to know that your money's protected, and that's the point of contracts, the assignments, whatever the agreements that you're going to use. You want to know that it's protected. If you don't do a good job and you don't charge a price that's kind of considered the going rate, you're going to have problems anyway. You ain't going to be in business. So I agree 100% what Ed was saying. It's not about the AOB. Contractors don't, equipment doesn't ruin buildings. Contractors who don't apply the equipment, don't apply the technology, don't clean, they're the ones who are at the problem. It's that part of it. So if you've got larceny in your heart, you got larceny in your heart. And that's the end of it. And that's not a good thing. So I think that
Pete, Ed, I know we're running up on the 2-hour mark. Do you need to run? I know you're a busy guy.
You talking to me?
Yeah,
that's right. Right. So
I have a meeting that starts in 9 minutes.
Okay.
Yeah, right. So I'm going to go into the wrap.
Okay.
I'm going to go into.
Let's let Ed go, and then we'll do the round.
Right. You have some stuff you want to say. You're going to say, and then you do it, and then I'm going to do the wrap up. Ed, you'll have to listen to the last part of that wrap up. What did Global Dog say? Go ahead.
Great job. Happy birthday, DYOJO. What a wonderful time, and a great year and many more years ahead. Thanks for the opportunity to participate today, and keep up the good work, the both of you.
Well, thank you so much for being generous with your time, Ed.
All right. Thank you, guys.
Ed, I love you, brother.
Love you too, Pete. You too, John.
love all around. Oh, man, you are so ripped.
All right, John, is it back to me?
Yep.
Okay. You guys were talking about, and I guess John Lapeterre kind of brought this up, and you commented on that. When you're talking about the gouging and the insurance company, that there a lot of the changes in the AOB law in Florida were designed to protect the homeowners. There's probably some truth to that, but it's often viewed with skepticism. The same thing is with these insurance companies. They have these big fraud departments, the SIUs they're called, to investigate fraud. And the argument in Florida with the AOBs is that with a gouging or improper use, or attorneys that file these thousands of claims, like was discussed, that this was increasing the rates of the premiums of the policyholders, and it hurt the citizens of the state.
Yeah,
there may be a little bit of truth to that, but there's also part of that narrative. That's the insurance company saying that. So I think a lot of them look at suspicion. I mean, look, unless you're a crook, nobody's going to endorse fraud and want to have that. And it does hurt everyone. But there's probably far more of that goes on, not in the property industry, but in the auto, the collision, the glass bandits, they call them. And of course, in the Medicare fraud that was brought up in these things that affect policies and premiums in general. So I think sometimes the government does need to be involved, and these companies need to have that. But it's not always the truth. You have to always put in the context where the narrative is coming from.
Well, that's the extreme is somebody abused it. Let's take it away. Obviously, that's whether.
No, right, exactly. And none of those work, John, like you said.
Not. It should be a right.
It went from one end to the other. There should be some modicum of moderation. There's usually some issue that's involved. Fix that issue. Don't throw the baby out with the bathwater.
Yeah.
So the big thing is extending these out clauses in the contracts. I think are important to protection, because we're extending credit. So the most honest and reputable contractors want to use these so that their interests are protected, and they feel that they're going to legally be able to get the money that's owed. Considering their pricing is in line. Nowhere does an insurance policy say that it pays the cheapest, the lowest price. Marty has talked about that for years. That's out there. The frequently asked questions, the homeowner bill of rights. This is something that Ed and the AGA is working on. It doesn't say that, but prices should be commiserate with rates, prevailing rates in your area, and everybody knows that. So it's very important, John, like you said, the customers should be included in the loop. Here's the difference. what the customer may get doesn't have to be the level of detail, but they do need to get some recap. Meaning, oftentimes, if a doctor or a hospital is going to bill your carrier, the Blue Cross Blue Shield, Cigna, whoever it is, they'll send the customer and say, we billed it. And they're not going to show pages of bills, every line item for every Tylenol that they charge. But they're going to say, hey, here's your cost. And, some of them, the laws, the HIPAA laws do that. And they say, but we billed it. So that way, if money comes to a homeowner, and this is what I always felt, I let a homeowner know, because if that check sometimes inadvertently went to the homeowner and our name was on it, they're going to know that's our money. You need to call us. Right?
Yeah.
So that's where you have to send them a bill. If you never send them a bill, they don't always know they owe them the money, or that the claim has been cleaned up. So the customers, you have to establish what your company communication process is. Insurance companies dealing direct is different than dealing through TPAs. They have their own sets of rules. And then, what does the customer feel comfortable with? You don't want to bombard them, but you don't want to keep them out of the loop. So that is a subjective thing. Okay. Ed did talk about this is, the bad faith claims, insurance companies, the bad faith is put into effect. They have to do an investigation. They can't just randomly out of hand deny a claim, although it won't. That's part of what the policy reads, which is a contract. And if they violate that, then they could be subjected to these bad faith claims, which are punitive. The courts essentially will charge the double, triple of what the cost of something would be. That the similar where you'll see that are in these civil cases, like against the tobacco industry, Erin Brockovich, the movie, all that kind of stuff with the PG in California. That's what those things are about, because the corporations, these big companies, they know they were doing something wrong, and the courts and the government, they don't like it when they essentially abuse the citizens and people that they have an advantage. And so that's kind of the point of really all that. So a couple of other things. So let me talk about a couple of things that we're going to do. We kind of set the table here, John, with the standard of care with the first part of Ed's discussion before we move directly into the AOBs. And I guess we can basically tell your audience now that I have been working with you, and shortly I'll be following up maybe next week. We're going to do a show on standards in the industry. It's going to be kind of an historical show that takes us through, why did the industry have standards? How did they evolve over the years? What led them down the road to be an ANSI standard? And what do all these things mean? And we're going to have a very unique panel. We won't tell you who they are now, but we're going to have an old dog. We're going to have a very prominent person. And then, we're going to have a scientific person, and we're going to have someone who's in publishing. Anyway, it's going to be a very interesting panel, be a terrific show. But a couple of things I'll point out, and Ed mentioned this. Our industry, the standards that we have, they're called voluntary standards. A non-voluntary standard is like a code, electrical code, things like that. So almost all industries, they're voluntary. So by having the ANSI process, what it does, it adds validity to it. The other thing are the two kinds of standards. They're what are called prescriptive or procedural standards, which is what generally our industry standards are. And then in some industries, they are performance-based, which in other words, instead of saying these are the steps you take to accomplish whatever that standard is, here's the criteria that you need to reach in order to get to the end goal. And our industry now is going through changes. So instead of listing every step that it takes to evaluate, how wet a wall is and what it'll mean to be dry, I tend to think there's so many variables in that if we start to put the general criteria, I don't know that we'll ever be total performance based. They do build houses in certain industries based on performance, and there are builders who are performance based builders. But I think we're going to move to a hybrid in our industry where we kind of have a combination of that. You can see it starting to happen now as it starts to evolve. So knowing these different types and styles and how they operate, I think are important that the people understand, what that means to contractors, people working in the industry. Ed talked about the action verbs, must, recommend, highly recommend. Then he talked about the disclaimer that if you have to change something in the standard, it allows you to do that. That took place at the very first S500. I was part of a small group of people in the final editing committee that established that language. We knew way back then, after the document, before it was going to go out, we had a legal review. We realized that number one, we did have to have a disclaimer in there so that sometimes people would modify, and we want to give an opportunity where they could do that. And that's important. And Ed commented on that. But the second thing was all those words, which now have evolved to should, and there's a variety of them that you're all familiar with. Those were created several years ago because those were the action words that will ultimately determine the level of work that you do, which ultimately will affect costs. So the industry was very diligent at the time. And we got into a lot of discussions so that we could defend the decisions when those documents were published to property owners, to the FEMA government, to insurance companies, etc., of why those words are in there. And I think that the committees who do the hard work in that, I think they take those very, very seriously. And knowing that's a very important part of understanding standards. And I think that show, John, I think they'll comment and talk about that. That'll be the kind of things I think you'll ask those questions. I probably didn't need to tell you, but I think you probably will, because those are very important questions. So I guess one of the things that I think has differentiated the kind of the ethical contractors from maybe some of the ones that were more questionable, and I'm certainly not going to judge. I think the market judges, we're the marketplace judges, But, well, I think most of the time they probably do. I mean, nobody wants to get in a lawsuit, because by the time that happens, the lawyers are the ones that normally make out. Like Ed said, if you're going to end a contract, try to find out how you can agreeably end the contract so that it doesn't go to that particular point. But one of the things that's very, very important that Ed talked about with these assignment of benefits, or with these authorizations, whatever kind of contracts you use, teaching the employees, the project managers, the lead technicians, whoever's going to execute them with the customer, doing the role playing is an important part. That's something that Ed's done for years, and more of that is happening, because that's important, because that's what establishes the contract and the meeting of the minds. So if the business owners and people on this line, train your people in that area, either learn it yourself and train them, or bring someone outside, that'll be up to you. But training the people to execute and know what their level of authority, I think, is very, very important. The other thing is make sure that you notify the insurance company. Ed talked about that. You notify the company that you have an illegal assignment. Way back in the day, before assignments were used and we had direction of payment, and most of the time they were honored, not always. We always would put on the front of our estimates or our final bills a recap sheet with the basic cost, and then the detail will come after it. Because most adjusters, most people, they want to know, well, how much is it? What's the simple breakdown, right? I call that a recapitulation, which means to summarize in short form. But then we always had a special note back in the days before everything was as computerized as it was. We would highlight it and we would put on there, we request direct payment or inclusion of a name in the draft as assigned by your insured. And then we put a copy of the work agreement. We put a copy of the certificate of satisfaction. We'd highlight an area on there back when you used to have to make copies before everything was digital. That was the package that went in. Now you do it digitally, you do it faster, but we're still doing the same thing, aren't we? It's still the same thing. It's just, we're just not doing it. We're saving the trees.
Different delivery medium.
Yeah. So keep all that in mind. Now, I will say this. One of the things that REA learned years ago, and the IACRC, they have codes of ethics when you become certified that you agree to. In the water law specialist program is something that I obviously was one of the founding fathers with Cliff Zlotnick and a few others. Or was the one I always like to talk about because it lends to this topic. It says that a water law specialist will document their charges and their invoicings something along to be consistent with industry practices, right? In other words, we're not just going to write a bill, it's 10 grand. We're going to do it like that. And then they have this specific language. It says, we are willing to explain to defend those charges at any time when asked. That's an important point. When somebody questions your bill, don't assume they want to cut the bill, they want to knock it down, whatever. Sometimes they just don't understand and they're asking a question. So be careful not to put the wall up and say, well, how can I help you? Let me explain that. And then they'll talk about it, and then you'll go from there, right? And so that point of the code is a code. I mean, if you look at what's on the hat, it says we make it better. But if you go to the REA website, the full motto says we make it better, we promise. So REA members are basically telling the world that they promise they're going to make it better, and that we have a code of ethics and conduct that we abide by. And I think that's a big thing. I mean, people come to associations, John, to associate, to do together what they can't do alone. That's a big reason why people should join. I mean, obviously education, the networking, there's a lot of other reasons to see the expos, but they're commercial venues. You can see some of that stuff. You can go online that you don't need to go. But it's the personal contact, and it's being part of a process to be engaged. Associations don't survive just because somebody pays their annual due. They pay because people are engaged. They're on committees. They purchase the products. They attend the seminars. They go to the conventions. And then it impacts things like the AGA, setting certification standards, the body of knowledge, industry standards of practice, etc., like that. So I guess in closing,
I like that code a lot. The we agree to explain and defend, our bill, because you see a lot of that in the comments. Why is this adjuster asking this question? Why do they want my dry logs? Why?
Sometimes they're just curious. Sometimes they don't understand. They're just and sometimes they need to know in their mind, so that when they're asked, they can document it, or why did they pay that bill, or why did they agree to that scope. A lot of times that's all it is. But then as soon as you start getting into the confrontational thing, and the communication slows down, and that doesn't always end in a good way. So look, the history of things that led up to all the stuff that Ed's been talking about now with the AOBs and all this, it started in 2007 in the state of Colorado with what was called anti-steering legislation. And a fellow named Joe Arrigo out there has been a member for many years of the association. He won the ML King Award that year. And Marty called him a hero because he basically spearheaded in the state of Colorado, this anti-steering legislation, which essentially, will prevent insurance companies from steering customers to one, particular vendor that they like to do. The problem with that, it was a great initiative, is that once it was approved, the next step to enact it as law, it has to go to the regulators. And I don't think it actually went to that point. I think somehow it stalled with the lobby or whatever the case would be. But it was a valuable lesson that the industry learned. And then now with the AOBs, it's kind of the next generation of this evolution. I mean, Florida was kind of like the spotlight of the whole country, and really the whole world was looking at Florida because of these AOB laws. And did some people abuse it? Yes. But it really wasn't the AOB. It was, Ed talked about it, and the insurance thing he talked. The old AOB with the fee shifting was a one-way street. Most laws a two-way street. It's give and take. But of course, here's the downside of that. Most people don't have the money to hire a lawyer. They would take it on consignment, right? So that it was an unlevel playing field, and that was the original argument in the early days of the AOBs. When this movement took place, is that the AOB allows the playing field to be level with the fee shifting statute. But it is where it is. Maybe over time it'll change. Minnesota is another state that wasn't mentioned. They've been very friendly to. They tend to be more friendly to the insurance industry with some of their legislation. I've been told by some of the people that I work with in the industry, and it varies from state to state, like Ed said. So the final thing I want to say is I have a little piece of paper here, and I actually emailed this to Ed, and earlier today, after I reviewed and made some comments on his assignment and benefit book for whenever the second edition will eventually come out. And this will be in the future stuff that I'm going to send you, John, on the resources. But it's a restoration contractors list for dealing with mortgage companies. And this was a panel presentation in Myrtle Beach in March of 2012 at the REA convention. We had two attorneys there, Harvey Cohen, who's a Florida attorney, the biggest advocate for the AOBs. And then the other one is a fellow named Ron Kronthal, who works for one of the big, large restoration companies, Rollin, who now they're part of the First Onsite group. And Sam Bergman he was past president of our association. But Ron was their corporate lawyer because they do national work and they're licensed in many states. And his job was internal corporate lawyer. Most restoration companies don't have this. They usually have outside counsel. So they gave a presentation on this checklist for contractors. Remember I told you this story? Wells Fargo and B of A and these mortgage companies were very damaging. And let me tell you, Ed, one of the things that Ed has said, he didn't really talk about it today, said there's a lot of other threats that can affect the work that restoration contractors do way beyond insurance companies and TPAs. Some of it has to do with real estate law, things of this nature. So somebody has to pay attention to that. Well, the mortgage companies are a big one. So I did a recap of that. It was published as part of the proceedings. It was never published in the magazine, but we've used it for education and training in our project management WS courses for years. I think you should have Ed do some research in this, John, and you should have a future show on dealing with mortgage companies, okay? For the contractors specifically that do the full service stuff, or any place where a mortgage company is involved and mandated under the policy that the mortgage company's name must be on there to protect the rights. This becomes very tricky dealing with the contractors. So to wrap up, I'm gonna review the 10 points that was recapped in this. The first thing is he talks about that you have to establish what he calls an SAT philosophy. And the S stands for you got to get set up, and the A stands for you have to be aggressive, and the T stands that you have to be willing to threaten. In other words, it's a process. Then he talks about using an irrevocable assignment, and Ed actually has that in his assignment of benefit books that he released, and he did talk about that. There's another language in there. It's called that you're an attorney in fact. This is additional language that states that you can serve as an attorney in fact. I'm not going to get into the legal interpretation of that, but this is what the lawyer, this document before it was released was signed off by both the lawyers. They signed off on every word. Then they addressed the use of an AOB clause. They also talked about having a rate sheet that is actually integrated into the contract. Ed's talked about this. If the best contract from a price standpoint is to put a number in there, 5,000. That's a solid number. That makes agreement. But most guys, we don't want to do that. We're standing knee deep in water. We really don't know what it's going to be. So what we do is we go to the second best. We have a sheet. We say what we're going to do, and we talk about the charges for those items, and we try to match them up that our scope matches how we're going to charge. So in that case, the next best thing he calls, you take your rate sheet for those services, and it's integrated as part of the contract. Many guys have that as a separate item. The customer will say, hey, here's the sheet. But these guys suggest you integrate it into. It's not necessarily it's not going to be a whole full Xactimate, but it's going to have 10, 15 items of whatever the main mitigation things. A lot of guys charge on rate and materials. Maybe they charge on unit costs. Doesn't matter how you charge; it's integrated in. Then we talked about this unjust enrichment axiom. So let me explain to you. I read the definition at the beginning of the show. What the unjust enrichment means. Let's say that the owner is out of town. Let's say they're in Hawaii. You're dealing in the building with the property manager or maybe a tenant. You go in and you do restoration of that property. Maybe do emergency work, but let's say you actually do finish work and you run up a bill, whatever the number is. Let's say it's 10 grand. All right. And somewhere along the line, you try to document everything you did through a phone call. In the old days, you did a fax. Now you'd email them. They do a PDF, whatever it is. Right. But let's say something's wrong. It was the wrong person. They didn't execute it right. They did something where they want to wiggle off the hook. And they say, well, I didn't know you were going to do that, or that person wasn't authorized, and I'm the owner, and we don't have a contract. Well, if we go to court, and let's say there was a mistake, or something was just an honest error, like I said in the definition. If you did the work, and the owner of that property has an improvement to their property, they've been enriched. Courts don't want to do is see people who in good faith did an honest job and say, well, we ain't going to pay you. Now that's different than the contractor who was unlicensed to do the work. And in that particular state, they said you don't have to be paid. That's different because they want to stop unlicensed activity. We're not talking about that. We're talking about a guy who followed everything and some little thing. And now you got an owner who was either a crook or they just say, hey, we don't want to pay the guy. Whatever. One of those four reasons I've already talked about. At that point, the courts will normally get the contractor paid because it's unfair to let the property owner leverage and do that. That's what that's called. The final thing is you have to have what's called a permission to talk. This is critical. Ed talked a little bit about the AOB. What the assignment does, it allows you to talk on the insured's behalf to the insurance company. Otherwise, they really don't need to talk to you. The mortgage companies are even tougher. So there's a language in there that says permission to talk, which means that when you call that mortgage company, their mortgagee has given you permission to talk to them. Then you have to deal with what's called the lost draft department. This is the people in the mortgage companies who deal with the money from insurance claims on properties that they have insured, and they want to make sure that the work gets done properly and paid for. Because if they ever have to foreclose in that house, they don't want to have to say, well, somebody ran off with the 20 grand, they didn't do the work, and now we got to put 20 grand in to even get the property back to full sale, or we have to sell it off at a fire sale price, no pun intended. And then finally, if there's going to be interest, you should always have late penalty charges. A lot of times you won't collect them, but sometimes you can use it as a leverage. Well, if you pay me now, we'll waive the interest you owe. But, the credit cards are not so willing to do that. You don't pay your bills on time, you owe that. Contractors are afraid of doing that. I say do it because it's good business. And then finally, you have to decide, and this is a very tricky one, John. You want to do a credit check on people. That's really critical, all right? Because do you have to ask for permission? When you do it, does that affect their rating? And so let me tell you why you want to think about it and what the issues are. You're not going to do that on a small job, a mitigation emergency job. But if you're going to move to doing finished work, let's say you have all that agreement signed, assignment, you have all the legal things signed, right? But let's say that homeowner is in arrears on their mortgage. Let's say they're really bad credit. Then you got to determine, with all the stuff I have, I got a bad customer. Because at some point, the mortgage company is going to want to try to get whatever money they can. And a lot of times they go after the contractor because the customer's in arrears. That's not your problem. You did the work. Mortgage companies are ruthless. And then the other thing is what about the fact that they may owe money to everybody, and they're going to look wherever they can get it. And Bob Paccarel had a story on that in there that dates back for years. That is a touchy story, a touchy clause in the society we live in today, but it is something that should be discussed in-house with the project managers, with company ownership, with their attorneys and their accountants, so they decide what their policy is. My hope, with encouraging Ed to maybe take this as an AGA initiative and for you to have a show on it, is that we start to establish some industry protocols, what would be best practices in this area. Nothing is exactly signed in stone. We're just saying these are the kinds of things. And you know what's so important about this? This company and the attorney who was talking about it, they actually did all of this stuff. The only one that they didn't was that last one in interest. I put that in there, and he goes, you're pretty smart, Peter. And that's a real touchy one. I go, yeah, it is, but shouldn't it be addressed? And he goes, you're right, it should be. They signed off on that language. I said, yeah, put it in there, because there's more language that explains in the document. But essentially, we're just saying these are the issues, and you're going into reconstruction. There's a lot of money at stake. You got to pay your suppliers. You got to look at progress payments. The difference is when someone remodels a house and they do a contract with a remodeling contractor, they maybe have already gotten the loan. You have the permits. They plan the work. This is unplanned work, and you got insurance companies, mortgage companies. It's a different situation, and you put at bigger risk. And I'll close with this. Why is this so important, and why did I pound on it? And why am I trying to get you and Ed to go in that direction? Here's why. I was at a school at Jeff Cross does these schools, his restoration strategies. He has Peter Crosa, a number of people, and talk about how to work with the insurance companies, how to do all that. He's very well known. It's all over the clean facts and everything, right? And he comes down to Florida once a year, usually at a local John down in the Ramsco, one of the local suppliers. He'll put these shows on. So one year, this is going back at least 10 years when he first started doing this, we had a pack room, about 40 people in there. There was a global audience, even though it was just Florida. I'm not global. It was a national audience. They came from all. There were two guys there from North Carolina. And the guys were almost in tears, the man and his son. This whole issue of mortgage companies came up, and he said, we're right on the brink. We think we're going to have to go out of business and close our doors. I said, what's going on? He said, I can't remember. It was one of the large banks. He said, well, so we're in a big dispute with them, and they owe us $345,000. He said, we can't take that kind of hit. We're going to go out of business. And it got that far. That was at a time before this document was even created. And that led me to bringing that to the association, and then bringing it as an industry issue, which ultimately led to Executive Director writing that article, because that was real life that affected real people's life that was happening with a guy in there that I talked to that told me that. And I'm thinking, wow, that's something. And, to the bank, all they wanted was the money, because the money was owed somewhere. but did they care about the local guy that they were going to hurt in his
No.
business? I guess apparently not. I don't know how it ever turned out. I wish the guy the best luck. I hope it turned out okay. I never really knew after that, but at least in my mind, I took action to try to have the industry address it on a larger scale, and it still needs addressing. It needs big time addressing, and it needs the kind of addressing that the AGA, the REA advocate, and the restoration lawyer could do. So I hope that's on your radar screen there, the intentional Mr. Isaacson, because I think this is an important issue, and I would think there's a whole generation of the restorers that are DYOJO guys. They got to deal with that.
Also, one of the reasons the mechanics liens are so important, right? So that you get yourself in line for if somebody's finances go haywire, that you're in line for collecting.
Right. That's an entire discussion all to itself. That's state driven, not just mechanics liens. In the state of California, they have a thing called a preliminary lien notice. You're actually obligated to do it. A lot of contractors don't do it, and particularly the subcontractors. And the reason they don't do it is because the prime contractor, then the building owner gets that, and they don't want them to know who their subs are. But in essence, they're kind of encouraging them to violate the law. But if you don't file it, you don't protect your rights. So one of the things that happens is in California, and maybe these laws in Washington too, is that by following all those laws, the laws are not only designed to protect the property owner, but they are designed to protect the contractors who want to operate legitimately, meaning the lumber yard, the painting stores, all that. So what happens is then that's when you have when you do the wind down, you have the release of the liens. In certain cases, they hold a certain amount till it's done, and then that's how you get paid. It's a process that allows you to come to conclusion. So what happens is the customer, you as a contractor licensed, when you need to follow the rules and the law, but the customer, they need to be aware of this. And what happens is if there's too many people out there ripping people off, that's when you get the public adjuster, the attorney, the people, because that need is created in the marketplace for them, right? And or insurance companies or middlemen that may not want to pay. So you have to follow the laws on that. And we actually, the funny you brought that up, I was a contractor for 20 years in California, and we dealt with a situation, a pretty large job, with a contractor that wanted to work us over. And one of the things that we did, he actually told us that he didn't want us to file this preliminary lien and trust him, and then he tried to work us over later. There's a lot of money at stake. And what we did is we filed a lien on the property. It went to the homeowner. It was actually an unenforceable lien. Now, in some states, it's actually illegal to do that. This was years ago. The unenforceable lien, the homeowner called up the contractor and said, how come I have this lien on my property from one of your subcontractors? He said, you need to fix it. And essentially, I used that to negotiate to the guy to live up to the original deal we had. I said, we had a deal, and now you wanted to change it. You wanted to work me over. I knew that lien's unenforceable, but I said, now we're going to settle. He goes, yeah, you're right. And so we went down to the city hall to take the lien off, and I actually made him bring me a certified check. I wouldn't accept this check. He said, you're really playing hardball. I said, you started the game. So I said, we're going to go down there. We'll exchange it. We're paid. Your homeowner's happy. You move forward. The lien's off, and we were paid. I was a project manager for the company, and I had to report to a guy because I signed off on that job. And the owner knew him too, and he said, Pete, try to see if you can fix it. And I said, well, this is what we have to do. And that was a long time ago. I wouldn't encourage incentive to do that again today, and I'm certainly not encouraging anybody to do anything illegal, but the point was you can get real dirty and nasty out there, and it's these lessons that are learned and passed on to the next generation is what you talked about. In that deal where you said, you can dang, how'd you say it, Janet? Dang, you can learn quicker, ask them. Well, this is why.
Shorten your dang learning curve.
Right, shorten your dang learning curve. This is the reason why you want to, come to the conference and, the diamond anniversary, why you'd want to belong to an association, why you want to call in these podcasts, why you want to get a book, why you want to, go do whatever, is to learn from others that have been there. These are the lessons they learned, and how do you pass them on? But let me just say this. We don't dwell on history. We use history to learn its lessons. So how can we apply those lessons to the present challenges we have? You always look to the future. It's always about the future. And you should never forget that ever. And I think you're a good example of that. the next generation of leaders and restorers in the industry, we're going to take it higher and further. Sir Isaac Newton had a quote that said, in order to see higher and further, we must stand on the shoulders of those that came before us. And that essentially, when Joe Stebrick in the Building Science Summer Camp and this, that was the whole purpose, is that we want to learn from those that came before us. And then we want to apply those lessons so that we can take our industry profession to the next level, wherever it is. His profession started with the Greeks and the Romans 2,000 years ago in architecture, and the industry's evolved. And essentially, a lot of us embrace those same principles and philosophies. And I think unknowingly, you, probably stumbled and embraced that too, is that let's learn what we can, and then let's see how we can apply it to do a better job and to create a better future for ourselves, our family, our employees, and our customers. I mean, at the end of the day, that's the most important thing. So,
Mark Springer, leave it better than we found it, right?
Well, absolutely. You always want to do that. And anyway, look, it's been interesting.
There's the quote of the day. It's been interesting.
Yes, it's definitely been interesting. I enjoyed getting to really interact with you in this way. You know, we've had a handful of calls, we've had some emails and stuff, and of course, I'll get to see you in June at the REA in Orlando. And I think that quite frankly, I mean, anytime I can interact with Ed, Ed's been really busy. He's had a lot going on lately, and it was just fun. And I think he gives me far too much credit for his success. I mean, I a little pat in the back, I like it, but that doesn't really motivate people. I think that, Marty was like that. We rather don't talk about that. Let's talk about what needs to be done, and let's just talk about doing the right thing. That's what we're about. And having a code that you live by and that you apply fairly, and shared values and a common mission with people. And that's what how you build a company, how you build an association, how you build an industry, basically. So I'm anything I can do to help the next generation. I'm all there for that, as long as I can. So they don't need me anymore to wheel me away, tell me to go out and graze. I mean, I'm on my way out to the pasture. I just ain't ready to graze yet. But anyway, John, that's I don't know if there's anything else. You have any other questions? I mean, do you mind if I put, that little thing that we're working on in January for 2022 I talked to you about? Do you mind if I make a little comment on that for your group here?
Fire away.
This may be the first official announcement publicly to anyone on this. It's happening on the DYOJO in the last few minutes of the call. Bam! So I have a handful of events that I'm personally involved with, and all that stuff's been on hold for the last year and a half, obviously because of the pandemic and the COVID. We've been in the Zoom world, and the in-person meetings are just starting to warm up. But one of the ones in particular I did last year was an event in Deerfield Beach, Florida. That's midway between Fort Lauderdale and West Palm Beach, called the Winter Break. It's the South Florida Mold Conference of Assessors and Remediators in the state of in the state of Florida. 20,000 of these guys. Every 2 years, they need special credit through the state to maintain their licensing structure or to be a licensed mold assessor and a remediator in the state. And we put this event on. We have a lot of the known industry suppliers who support it. And it started out being a Floridian event. Last year, it really was global because it was dovetailed off the IUQA, which was in the same area. So we had Aussies, a lot of Canadians. The borders were open. We sold the event out, and we're now planning next year's dates, and we haven't released it yet. I guess I'm formally saying if anybody wants to put it in their calendar, it's going to be the last weekend in January. That's the weekend before the Super Bowl, which every football fan knows is the first Sunday in February. So that'll be the Thursday to the Friday. Saturday is the 27th to the 29th. Ed made a commitment. I talked to him yesterday. We're going to do a special legal workshop. And then the theme of the program is going to be moisture, materials, mold, and methodologies and assessment and remediation. We're going to have moderators. We're going to have high-level speakers. We're going to have some young generation people. We're going to have some of the old-timers. And we're going to have a mix between assessors and remediation and restoration companies and roofing companies, and quite a mix. We're anticipating a larger crowd this year with more vendors. A larger sellout of the event. It'll go quick. and John has agreed to come to the event. All you DYOJO fans out there, he's going to be in Florida next January. May or may not bring some of the family, and great time of year to come. And I'm gonna have a role for him to play in the event, and hoping that he'll encourage a lot of his the fans and people that follow his show and read his books and believe in being intentional.
Yeah.
Maybe we'll put that on the calendar. We're going to have some save the date stuff going out soon, but here's going to be a little theme that we're going to start with. It's going to be the winter break 2022 with the dates, the January dates, and then a little statement. And right now I'm working on this with Land's End to get our mask finals. We're going to say back to normal with a question mark. We hope we're back to normal. We don't know if we're back to normal.
Yep.
We want to be back to normal, but we just don't know. We're planning the year out. So we're ordering a bunch of masks from Land's End. We're going to have a little logo. We're going to have some signage. Nice. We'll get some promotional stuff out. We want to save the date. I'm working on a solid program. We're going to have a couple of IAQ radio shows directly on site and then a follow-up highlight show. And I kind of tend to think there may be a DYOJO podcast in there somewhere along the line too. Not quite sure yet, but something tells me we're going to be going down that road, my friend. And anyway, it's going to be fabulous. I mean, things are opening up. There's still a lot of Zoom stuff the rest of the year. There are a few, we're going to be safe and we're going to follow the rules, whatever's required. We just don't know what they are. But essentially, we've done 2 events at that hotel. We did the town hall there that you talked about. And then last year's winter break. This will be our 3rd event. And it's solid, easy to get in and out of, great venue, great time of year. We're hoping that those of you around the country will help support it. You'll get continued education for all the industry stuff. If you're licensed in Florida, you're going to get those credits, the 14 and the even year. And basically, we're going to have a good show and just be great place to come, particularly if you're in the cold country. If you don't need much motivation to come get educated and maybe take a little vacation, be able to write the trip off. That's what entrepreneurs do, is you try to do stuff like that. So anyway, you're not just going to come down and take a vacation, I wouldn't think. But if you can get the education and the credits, do a little network, and maybe that little give you that snowbird thing, give you a little extra motivation. So anyway, hey, just tell me when it's time to shut up and when we're logging off here, John, because I figured if people had to go, they're going to go, they're going to do what they're going to do. They can decide. Listen, they're going to say, "Oh, Lord, John, that should have been a 2-part show. You guys went on for 2.5 hours or however long it was. What's going on?" I say, hey, you can always hit delete. You can always hit stop. You can always, I got to go. You always have a choice to do that, right? I'm just having fun with you,
and it's the birthday bash. We do what we want. So
that's true. It is the birthday bash. Right. So, anyway.
But I think people
that's all I got, buddy.
People don't realize how long we've been working on making this happen. So we're gonna indulge. So I appreciate it, Pete. It's been fun getting to know you and kind of making this all come together. So I appreciate it.
Yes, it's great, John. It's been really good.
All right. Any closing thoughts as we wrap up?
Not really. I mean, I think Ed had a chance to make his comments, and we made Mr. Springer happy because we gave a couple plugs to come to RAA, and you paid homage to the OGs before anyone knew what a podcast was of Radio Joe and the Z-Man, and we talked about some of the upcoming events and the shows and industry stuff, and we got into a lot of really in-depth real life stories and some of the legal tenets and build off that Ed shared. And then I think finally we laid the groundwork for the standard show, and I think this mortgage stuff I think is going to be big, and I think that the AGA will take on the issues based on what the consensus and the will is and where they fall in the pecking order of importance, but they've been doing a really good job going down the list, and now maybe this will rear up. And of course if Ed wants to do that within his own company that's not part of the AGA, certainly could do that. And I think it basically builds off of the assignment of benefit book. It could be a separate book. It could be an addendum book with the next edition. But get your teeth into that. And have you seen that document, John?
No. Nope.
Yeah, I'll I'll attach it. I'll send it to you when we hang up. I did send it to Ed. It was in a separate chain with him, one of the threads we had going. But I will send it to you, and if you check it out, it'll be part of the bigger resource. But at least you can look at it now. You can get it on your mind, get going, because I kind of think I know how you operate.
Well, and we'll we haven't set dates yet for that meeting of the minds, the standards podcast, but probably late April would be the goal. So
yeah, well, what happens is next week I have it on my calendar. I was waiting till I talked to Ed and we had this show, and I already have a resource Dropbox link put together for you. Then I'm gonna email the panel. I'll tell them who they are. I'll let you do that. They're very prominent. It's gonna be a great panel. And then from that point, then you can just move down the road with them the same way you did with me and Ed on this show. But I'm also going to send you that big link that with just the Watchdogs, and there'll be links for each show, and then there'll be the master link, and that's the Restoration Google's gift to Mr. Intentional, man. I mean, I love that name. Michelle gave me that name. It's really good.
Yeah. Well, credit to Michelle Blevins helped create that for the column, so I appreciate it. So, all right, well, we'll let you go and enjoy the sun down there. I don't have a window here, so I'm not sure what the weather's like. It was raining when I came in this morning, so.
Yeah, Jen, I've looked. The 4 years I worked for Dry's, the late 80s, early 90s, I lived in Skagit County, and you remember that going around Seattle, they have at the airport the little deals that says you don't tan, you rust in Seattle, and it just drizzles. So the rain's never hard enough that you actually need an umbrella. In Florida, you don't use it because it comes down so much, the wind will blow the umbrella away, so you just get soaked. You got to put the ponchos on. But there, it's just that general drizzle. So anyway, but it's sunny here. It's a great time of year to be down here. Of course, July and August is nothing like being up in the Puget Sound and going to the San Juan Islands. Some of the most beautiful places to be, and to get those great oysters and the salmon and all that fish up there. I mean, that's a beautiful thing of living up in the Northwest. So, everything has its pros and cons wherever you are. Sometimes it's good, sometimes it's bad. The old gypsy woman, taught a friend of mine years ago, said that, sometimes you have a good days, sometimes you have the bad days, that's kind of lessons of life, you got to take it as they come. So anyway, today was really a good day, John. And, anyway, I look forward to the next time, my friend.
Sounds good. Thank you, Pete.
Okay, buddy. Take care. Goodbye there, DYOJO audience. Anybody who's still on there, man, you hung in to the end. I don't know who you are, but I got a lot of respect for you. I hope you got some value out of it, and I hope it was infotaining, as Ed likes to say. Infotaining. Yeah.
Yep.
Okay. Take care. Great. Take care, my friend. Bye.
Thanks, Pete. Bye. Let's see. Well, there you go. Marathon for the birthday bash of the DYOJO podcast, the most mediocre podcast available for the property restoration. We've got it on the website. There's a bunch of podcasts that launched this year. So various aspects of wherever you're at on your restoration journey, entrepreneurial journey, and definitely add IAQ Radio to that list. They recently did Moisture Mop. If you want to watch the video, because they've got some diagrams and case studies and those kinds of things. So let's again, we do what we want. So we went almost 3 hours. So you're welcome. No apologies. So take us out. Where are we at?
This is the stupidest thing I've ever heard.